PRC Court into session. The lawyers will announce their presence for the court reporter. Thank you.
Taylor May on behalf of the Office of the State Attorney.
Letitia George on behalf of the Office of the Public Defender.
Thank you very much. Do we have private counsel here that wants to move something up?
Good morning, Judge.
Good morning.
Brian Bird on behalf of Zakiah Cook. This is 2021 MM 299-A-W.
Is it a felon? Where is it? Do you all know
It's
where?
a misdemeanor DV, Your Honor.
This is charged as a domestic violence and a resisting officer without violence.
All right. I might have some notes on it then. Is it misdemeanor, you said? Cook?
It is.
Zakiah Cook. Okay.
It is, Your
Got
Honor.
it. All right. And we can barcode that also. That is 2021 MM 299AW. Meets the PTR criteria, I think. Have you talked to the state?
I have not talked to the state, Your Honor, but in this case, I have reviewed the probable cause affidavit. There is a probable cause in the matter, candidly, but the...
You want to find out if the state even objects to PTR?
No, I didn't. I'm sorry, I
I
didn't.
mean, that would be helpful. You might skip the argument, state.
Oh,
You looked at that one?
we would be asking, obviously, for her pretrial release. There's no sworn statement by the victim, obviously. So I don't know if this case will ultimately even be filed as to the domestic violence battery.
Your Honor, state has no objection to PTR, given we don't have victim input here today. And given a rather small criminal history, and that she otherwise qualifies.
Right, so no objection to PTR, but still, because the victim's not here, we have to put no contact, separate residence until you can get in front of a judge and hear from the victim.
She understands. I've explained.
All right, so if she's got any guns, knives, or weapons, we tell her to put those in the custody of the arresting agency within 24 hours of release. They have a child in common.
They do, and that's obviously the biggest concern with the no contact order.
So, they could, if they have a third party to help with the exchange of custody and visitation, that's okay, like somebody's parent or something. And also, if there are any orders from Department of Children and Family Services or juvenile court, because sometimes it gets referred over there if the child saw anything, then you would also have to be consistent with any orders from DCF or the juvenile court.
Would Your Honor entertain, if the parties wanted to, before the order, a Talking Parents, the Talking Parents app, which we use in family court, so that they could facilitate just regarding the children?
No, because in criminal court, you're a family lawyer, right?
No,
Okay.
I've been a
All right, well,
prosecutor. I've been a
okay,
family lawyer my entire life. I mean, a criminal my entire life.
okay, sorry. We just have to wait until the other judge sees both parties, or somebody sees both parties and determines that there's no objection.
Understood.
Okay, Your Honor, just so the record's clear, that was a no contact with the victim, separate residences, one-time return with law enforcement, and no weapons and firearms.
Oh, yeah, did they have a similar residence?
No,
I believe she showed up unexpectedly to the
Not, Your
victim's
Honor.
residence.
Oh, yeah, this was the one with the girlfriend was there?
separated.
Oh, yeah, the girlfriend was there. So, yeah, you don't have any things at his house, right? Because you don't live together, so
I'd ask for a no return then, Your Honor.
don't return to his house. Okay,
Good? Thank you very much, Your Honor. That's all I have.
you're welcome. And Ms. Cook, that's because your lack of criminal history that we're not making you post bond.
Yes, thank you.
You're welcome. Okay. All right, we're back to, we're starting out with, well, there she is, right there. That, okay.
Your
Are we
Honor,
starting out with felony domestics, or do we have move-ups?
Your Honor, we have, we're doing move-ups?
We have move-ups?
Yes.
I thought they were for second session.
Okay, because I don't,
It says second session. Nope.
so the clerks have felony domestic, but, and that's what you guys have? I mean, who do you have in line? Because we can't, restart that thing.
Oh,
You guys have move-ups?
For second session, Your Honor.
For second session.
However, I did want to bring to your attention, we did have a reset yesterday. However, I don't believe it's on the docket for today.
Oh, really?
Yes, Your Honor. It was a reset for Jefferson, the one with the many counts of possession of ammunition.
I think that it should be on the docket because we have the paperwork, I think, in the second session, but, yeah.
Okay.
And I'm ready for that whenever they, call it up. Is that a move up or?
Generally, if it's a reset, it's at the beginning. I just didn't have any actual resets.
Paperwork?
Yes, Your Honor.
Well, me either.
I just wanted to make sure that it would be addressed today.
Okay, so we do have the domestic people here too? All right. All right, so is this Ms. Bell?
Yes, Your Honor.
Okay, thank you. And we have a witness. Thank you very much. I hope the court reporter can deal with this. Okay. We have 2021 CF 580580, Division 17. Ms. Bell, will appoint the public defender to represent you, okay? Sir, would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Was that a yes?
Yes.
I'm hard of hearing, so please speak up and you can put your hand down. The state wants to ask you a couple questions.
Good morning, sir. Can you please state your name for the record?
Eric Smith.
And what is your relationship to Miss Bell?
My child's mother.
Okay. Approximately how long have you known her?
About close to about 4.5, 5 years.
Okay. Are you afraid of her?
No,
Has anything like this ever happened before?
not to the severe of what the incident took place yesterday. No,
Okay. Do you want to have contact with her?
no,
Do you believe drugs or alcohol were involved in this incident?
no.
And are you willing to call 911 if anything like this ever happened again?
Yes,
That's all I have, Your Honor.
All right, sir, you came here for a reason. Did you need anything other than no contact? You need anything? I mean, she has a real low criminal history, so we'll talk about whether she can just get released. Do you have any concerns about that?
no, I don't.
Your Honor, may I ask an additional question?
Sure.
She otherwise qualifies for what's called pretrial release, which means that she'll be on a program and she'll be monitored and she'll have to check in with pretrial release services, but she won't have to pay a monetary bond. Is that something that you would feel okay with her being on?
Yes,
Thank you.
Okay, all right then. Okay. Well, okay, since it was hot grease, it's technically a felony. I'm not sure how they're going to look at it down the line, but, that's potentially enough injury for a felony. We'll see what happens. She doesn't have any real criminal history or much, anyway. Any objection to pre-trial release?
No, Your Honor, not
Right.
due to the victim's input here.
Right, based on her lack of history and the victim's input, we'll let you get out of jail through this program where you report to him and keep in touch. However, he's asking for no contact right now. And so unless that changes and you all both tell the next judge that that's okay, there's no contact, indirect or direct, phone call, texting, whatever. Now, you do have a child in common?
yes,
Right, so that could be through like a third party, like one of your parents or family members or something you could exchange for visitation and things. You hear me, Ms. Bell? Okay. Do you all live together?
no, ma'am.
Separate residents?
Yes,
Do you need to get some things out of the,
No.
no, okay.
Your Honor, state would ask for no return to the victim's residence.
No return to his residence, no guns, knives, weapons. If you have any of those, put those in the care of the arresting law enforcement agency within 24 hours of your release. And make your court dates. We do give you the address and phone number of the public defender's office, and you probably should talk to them so they can be prepared. All right, that's it. Thank you. All right. Is this Mr. Pravignon? This is a reset. They brought up Mr. Jefferson,
Jefferson?
and I think, let me go ahead and barcode this if I can find the case number. on this paperwork. This was case number 2021 CF 5716, Division 15. We probably did appoint the public defender yesterday, would be my guess.
We did, Your Honor.
All right, so, and I think the state was concerned, there's some PC issues maybe in regard to the ammunition, and also, did you get more from the police officer in regard to whether or not there's any constructive possession issue on there?
Your Honor, I believe the officer finding the firearm in the room with the defendant, as well as obtaining photos from that night with the victim, or with the defendant in possession of the firearm, would be sufficient, at least for count one.
Right,
I was not able to obtain, I did reach out to the officer. He didn't send me a supplement, however, it wouldn't be sufficient for court purposes. So therefore, I was not able to obtain a supplement as to count 2 through 15 as to
Right.
the ammunition, as it won't be appropriate for court.
okay.
Therefore, I just ask that you find PC for count 1 and stay the bond as set and ROR 'em as to 2 through 15.
Okay, so ordered. And was he, if I'm remembering correctly, I don't know if I have this in front of me at the moment, but he was out on bond for a similar charge? Yeah, I do. Okay,
Yes,
so-
Your Honor. He was out on bond for a possession of firearm and ammunition by a convicted felon, carrying a concealed firearm and possession of cannabis. Regarding that case,
2021 CF 1942AO.
yes, Your Honor, state would ask that you revoke due to it being similar instances and also a firearm charge.
I did actually look up the other case since we
4,000.
had time overnight,
Okay, thank you.
and it really, it's just the same stuff. Just the same.
Your Honor, I would just argue that if you are inclined to revoke, you revoke and double the bond amounts as opposed to holding him at no bond.
All
Your
right,
Honor.
I hear what you're saying, counsel, and I understand, and you're used to me already doing that in some cases, but I have to admit to you, that firearms make me really nervous for the safety of the community, and these guys, young guys, are just toting a whole arsenal of stuff, and so in this particular case, I'm going to err on the side of protecting the community and also just telling them, no, you can't just go back out and do the same thing. And I'm going to revoke and send you downtown and you can talk to that judge about it.
Okay, thank you, Your
Your
Honor.
Honor, on his out on bond, can you make any condition, no weapons, firearms, or ammunition? It should already be a condition as he is a convicted felon, however, I just.
I mean,
want to be clear.
I understand, and we'll order that. Okay. So we're back to the, all right, is this Mr. Prevignon?
Yes, ma'am.
Okay, thank you. This is case number 2002-1 CF 5514. It's going to Division 22. Judge LeBlanc. We can appoint the public defender to represent you, sir. This was a warrant that was signed by a felony judge in regard to an alleged aggravated assault with a firearm and battery. And so I guess the aggravated assault was alleged that you had a gun on you and when you were making threats to kill and allegedly also battering and there's some strangulation allegations in here. So another judge found probable cause and set bonds at $25,000, I think.
Yes, Your
And
Honor.
also no bond on the battery, and just to make sure that we looked at it before you came to court, and also with your criminal history and such. I don't know that the victim was notified and isn't here, so we'll clearly put no contact with the alleged victim. And no guns, weapons. And I don't know if anybody wants to be heard in regard to the amount. I mean, he authorized the IA judge to look at it and make a determination in regard to the amount.
Yes, Your Honor. In regards to the ag assault with a firearm, I ask that you stay what the felony judge set. In regards to the battery DV, I'll leave that within your discretion. I would just point to that the felony judge obviously thought that this was a rather pretty significant incident to set that ag assault with a firearm at 25,000. So I just also ask that you take that into account. Also, the defendant's statement that he's coming back to kill her if she went to the police. So I just ask for adequate bond conditions to help protect the victim, as that statement was made.
Yeah, and,
I understand, the $25,000 bond, I understand that another judge has set that. I would just argue that based on, his criminal history, he has no, convictions here in Florida. I see some arrests out of state, but I don't see any convictions. Your Honor, my client is, currently employed full-time, and he is denying all allegations in the affidavit. So I ask that you take all of that into consideration, his, criminal history, and consider lowering the $25,000 bond, and as well as taking that into consideration when you set the bond for the battery.
yeah, I'm looking at a lot of things now. For one thing, the allegations are very concerning, and Judge Alvaro clearly didn't want him to get out before we looked at it. If I were to take the allegations at face value, the $25,000 bond would be quite reasonable, I think. The other issues are that although he doesn't have convictions, some of his arrests were for things like aggravated assault, kidnapping. And I don't know how extensive that was. And also, the report wasn't made until about a week later, for whatever reason. I can't remember if that was where another incident happened, and maybe the person got worried at that point. But the good news is that we've at least gone a couple of weeks with nothing happening in the meantime. In other words, he didn't go back and fulfill those threats. Sir, I'll attempt to compromise all those concerns. Set the bond on the aggravated assault with a firearm at $10,000. And the battery, which could actually be filed as a strangulation, put that at $150 because it may be filed as a felony because of the strangulation element allegation. So if you get out, I want you to understand it's serious. I don't want it to be a piece of cake for you to get out. I want the message to be just stay away. Stay away. No contact. Don't return to her residence. If you have any guns, knives, or weapons, put those in the care and custody of the arresting agency within 24 hours of your release. Did I leave anything out?
No, Your Honor.
And don't make me sorry that I let you out. Also looking at the judge downtown, and I've got a pretty good idea of what he would do. So I try to save them their time on that. Okay, is this Mr. Santiago?
Yes, ma'am.
Okay. Thank you, sir. Case number 2020 CF 910780. It's in Division 20, and it was an ag-bat domestic violence, but it's alleged that there was a violation of pretrial release in regard to him having allegedly contact with the alleged victim on or about August 19th. And so, and there weren't any facts in the file. I haven't got my password updated because it requires some court administrative action, and I haven't asked him to do that. So I don't know what the original allegation was on the ag battery, but or even what the extent of the alleged contact was. So all I know is that, so he was out Contact allegedly happened soon after he got out. Nothing has happened since. But he does have some fairly extensive history in regard to domestic violence arrests. And that's all I know. So if you have any advice, both counsel, in terms of, if the facts are relevant, the only other thing that I really have in my mind is, okay, so the contact happened in August, and evidently nothing has happened since then. So my first impression, having not looked at the facts of either of those incidents, is maybe all we need to do is, add this, make him post some kind of appropriate bond, and
Your
let
Honor,
that case proceed.
in regards to the aggravated domestic violence, the underlying case,
Right,
that case happened in July of 2020.
right.
Um,
And it's still pending because they couldn't do anything during COVID?
It's still pending, Your Honor.
Yeah.
I believe he.
We filed a misdemeanor battery on it. We filed a misdemeanor DV battery, M1. The facts in that case overall alleged,
Is there a misdemeanor case number?
yes, Your Honor.
Okay, well, we should check that.
And for the court's consideration, my client was currently in classes. He's still taking the classes.
I don't think you're being picked up by the
Oh,
mic.
sorry. He's still taking classes, Your Honor, for this charge. He's working with his caseworker, Your Honor, so I just
Oh, you
asked.
mean batter's intervention class?
Yes, Your Honor, he's
Okay.
taking all of those classes. So that's what he's waiting to finish all of those things.
Okay.
In the
He's close to finishing batter's intervention?
Yes, Your Honor.
Uh-huh.
The underlying case, Your Honor, alleged that the victim and the defendant were outside of a residence. The defendant threw the victim to the ground and dragged her around. He then took her phone and threw it at her, hitting her in the face. A passerby witness stepped in. The victim was able to get away. There were several witnesses, some corroborating the defendant's side, some corroborating the victim's side.
Did it get filed as a misdemeanor?
Yes, Your Honor.
Oh, okay.
The reason it came in as an bat domestic violence is because the victim made a statement regarding the defendant made threats to shoot while reaching for his waistband, but he ultimately did not have a gun, and chased her around, threatening to shoot her and reaching for his waistband, but he didn't ultimately have a gun.
Okay. Right, and I didn't see the paperwork describing what the alleged contact was, so, it sounds like the kind of thing that happens right after he gets out of jail and he has contact, and evidently, we don't have any reports of that since then.
Your Honor, I am not sure. I know the victim has been cooperative with the prosecution. Has been cooperative with the prosecution of this
In other
case.
words, she still exists.
Yes, Your Honor. All my notes say she's being cooperative and wants to see the case prosecuted. And it is a violation of pretrial release to have contact with her in any form. I know Judge Bain and Judge Gibson both go into a pretty extensive colloquy with the defendants, making sure they understand what no contact means, that it's not indirect or in person or online or any form of contact. So as this is a violation of pretrial release, I ask that you treat it almost like a violation of probation and set it at no bond until the victim can be heard.
Your Honor, I would object to that, and ask that you set a bond here. My client, like I just previously stated, is currently working in classes to get control of everything.
Yeah, I don't need a repetition. I'll set bond.
Thank you, Your Honor.
And I heard what you said the first time, if you're repeating it. So, because, and I understand the state's request, it's reasonable, but it's been since August and nothing else has happened. He's almost probably through the batter's intervention. So, I have to respect the fact that it's a new crime, so I'm going to put $1,000 bond on it. That's not to minimize it. You have to post a bond, but, and it'll be added and probably funneled into that case, which probably did get filed as a misdemeanor based upon what I'm hearing. And just, leave it alone. Don't talk to her. And if you do, the state's going to be asking for no bond, and you probably, if you got a second one of these, you would be no bonded.
Your Honor, so the only condition is no contact with the victim?
No contact with victim. The next one is case number 2002-1 CF 4552 AO Division 17. Mr. Sears, we're going to appoint the public defender to represent you, sir. This was a warrant in regard to something that allegedly happened, I think, in April. And it was alleged to be a kidnapping with inflicting bodily harm, domestic battery by strangulation battery with one prior battery. And basically, those come in, no bond, and we have to deal with it here. So I read the affidavit, the sworn statement by the police officers in regard to the allegations. It reads a little more like a false imprisonment than a kidnapping. But other than that, there's probable cause. And it's alleged that it happened, I think, about a month ago in April. 1-year relationship, lived together. And some threats to kill, which are a problem. Something about allegedly threatening to blow the brains out, but she's here. Okay, so let's go ahead and get her sworn in. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thanks. And, I noticed some criminal history along with 5 failures to appear allegedly on the criminal history. So, ma'am, the state's going to ask you some questions. Thank you.
Good morning, ma'am. Can you please state your name for the record?
Ariella Sal Zachary,
Do you mind spelling your last name, please?
Zackery.
And what is your relationship to Mr. Sears?
Was girlfriend.
Okay. Approximately how long have you known him?
About 5 years.
Has anything like this ever happened before?
Yes.
Prior to this incident, when was the last time that incident occurred?
Probably October last year.
Okay. Are you afraid of the defendant?
No.
Do you want to have contact with him?
No.
Are you willing to call 911 if anything like this ever happened again?
Yes.
And do you believe drugs or alcohol were involved in this incident?
I don't know.
Thank you.
So I have a question, ma'am. In regard to the affidavit that the police officers submitted for the warrant, at that time, they said that you all lived together?
Mm-hmm.
Is that still happening?
No, I'm taking his things to his mom's house today.
Okay.
So he should not return back to my residence.
So had he been living there since this incident?
Yes.
Okay. All right. Okay, so generally what we do is allow a police escort for him to get some stuff, but, if you put the stuff over at his mom's house and we still let him, get a police escort to get some things if he thinks he's still got stuff over there.
Okay.
All right? You need anything else?
No.
All right.
Your Honor, this is a punishable wildlife offense. State is asking that you hold him no bond pending an Arthur hearing downtown in front of the trial division.
Your Honor, I would argue against that, being that, even though another judge has signed a warrant for his arrest, reading the facts, I would just argue that there is no PC for kidnapping, but that there is PC for false imprisonment in this case.
State needs to, respond to that, but yeah, go ahead.
And being that there is false imprisonment, I would ask that you set a bond in this case.
Your Honor, in regards to kidnapping, for a kidnapping, the state has to prove that the defendant forcibly, secretly, or by threat either confined, abducted, or imprisoned the victim. In this case, the defendant forcibly and by threat confined the victim by not allowing her to leave when she repeatedly asked to and tried to, and did it by threat by holding her neck, telling her he was going to kill her. 2, the defendant had no lawful authority to do so. He did not. She was of her own free will and volition to leave the residence and or the vehicle. and/or the victim's or the defendant's presence. And 3, the defendant acted with the intent to inflict bodily harm upon or to terrorize the victim or another person. In this case, the defendant inflicted bodily harm upon the victim by the strangulation, as well as other choking her, pulling away from the female, and the others choking her and trying to pull the female away from Miller's vehicle, dragging her towards the stairwell. She was fighting to get away from him. There is a kidnapping here, Your Honor, and another judge has already found PC for it, and it is a punishable by life offense. I don't know what will be filed later on, but there is PC for the charge that is currently.
Well, I understand
this
the other
court.
judge found PC. Ma'am, can I ask the victim a question? Now, a couple moments ago, you said you don't want contact, but you're not afraid of him. So, the state's asking for no bond. Are you afraid of him or not?
I don't know. Like, I want the court to handle it.
You want the court to handle it.
Yes. I don't want any contact with him. I don't know what he's capable of doing.
Okay, so you just dealt with it between then and now. Okay,
Your Honor, I'd also point out that he made multiple facts. This allegedly happened in a car. The defendant tried to take her into the house where he was making statements such as, "When I get you in the house, I'm going to blow your brains out." And was allegedly dragging the victim into the house.
okay, we don't need the repetition. I understand what you're saying. I really understand it. Ma'am, has there been any violence since the incident?
Yes.
Okay, well, tell me about that. I'm trying to figure out how safe it is or not.
It's not safe, Your Honor.
What kind of violence has happened since then?
Still fighting.
Fighting? Hitting?
Yes.
Anything of this magnitude where he won't let you leave or anything?
No.
Okay. Sir, you have the right to remain silent, and anything you do say is probably going to have convict you. I highly recommend that you don't say anything. The problem is that I got to somehow have ESP to figure out if you're going to go back and do anything like this, because this report is completely inexcusable, and the state is calling it a life felony. I don't think it's going to end up being a life felony, but, it really gives a judge pause, in terms of setting a bond. Except there's been a month and she's not hurt. She actually said she's not afraid. I think she just doesn't want to put up with the crap anymore. And she's completely done. And she's never, ever going to take that again from you or anybody. So, the main thing is you just need to stay away. And I don't have home confinement anymore. I don't have anything. All I have is bond or, not bond. That's all I got. So, you're leaving it up to me, but it's not like I can go watch him,
I know.
Your Honor, state would just ask that if you set it at no bond now, it doesn't mean that he will be sitting at no bond forever. He is entitled to an Arthur hearing downtown where there could be an evidentiary hearing to sort out more of these matters. But at the time being, with this being a life offense, there being PC for the charge, and the victim's testimony regarding that there has been continued violence since this incident, I believe it's appropriate to hold him no bond until he can get an appropriate Arthur hearing downtown.
All right, I understand everybody's arguments, and we are getting repetitious, so I'll just make a decision. All right, I totally understand the state's arguments in regard to the kidnapping. I'm going to set it at $7,500 bond on that. 150 on the bat, strangulation, and 100 on the bat. And I hope it's abundantly clear, I don't care about texting, phone calling, nothing. Don't talk to her on Facebook, don't talk to her friends to tell them to give her a message, just leave her alone.
Your Honor, you said 7,500, like 7,500?
Yeah? Just reading between the lines, I think. I know how this thing is going to go. And I try not to make more work for the judge downtown. So no contact, separate residence, police escort if you think that she still has some stuff in her house. No guns, knives, weapons. If you have any of those, put those in the care custody of law enforcement arresting agency within 24 hours of your release. You're welcome. Okay, the next person is Damien Wright. And that is case number 2002-1 CF5838AO. It's going to Division 15, Judge Wilson. Mr. Wright, we're appointing the public defender. You got 10 kids?
Yes.
Wow. I guess you'll be working until you get put in the grave.
Yeah.
Yeah. Good luck. So the allegations are battery, by strangulation and battery. They had enough information to file the charge. The wife, it's a wife, is not here. So we're going to need to order no contact until a judge can hear from both parties and determine that it's safe. Separate residence. I don't generally determine who gets to live in the premises, but if in order to comply with the order, you need to get some things out of the residence,
Yes.
we'll give you a police escort for that. I didn't write down if you have any kids in common.
Yes, I have. Well, my wife, yes.
Yeah,
2.
so visitation and custody exchanges need to be arranged either through a third party or follow any orders by Department of Children and Family Services or juvenile court.
Okay.
No guns, knives, or weapons. Put those in the care custody of law enforcement within 24 hours of your release. State, I was willing to set a bond on this. Did you need to be heard on it, or you want me to roll through it? I've taken into consideration he's got some prior history.
Your Honor, I just ask that you take account his prior history, and that he does have a prior failure to appear, and he has a rather lengthy DV history.
All right, sir. In regard to the battery by strangulation, bond would be $2,500, considering that you have some criminal history in regard to this, and $100 on the battery. I think you understand you're supposed to come back to court, even though we see that you have one failure to appear from 2016. And you probably know from that experience that you'll be no bonded if you don't come to court and they have to pick you up. Good luck, sir. Okay, we're finished with the felonies, and we're into the, is this Mr. Bromer?
Yes, ma'am.
Okay, thank you, sir. Okay, Mr. Bromer, this is filed as a battery. It's going to Division 50, 2002-1 MM 336280. Will appoint the public defender to represent you. They had enough information to file the charge. And there's some criminal history, but stated the paperwork says he meets the PTR criteria.
Yes, ma'am.
Any objection?
Yes, Your Honor, he does have a prior DV conviction. So if you are inclined to put him on pretrial release, I would just ask for pretrial release in conjunction with a monetary bond.
PTR plus bond is what you're asking for?
Yes, Your Honor.
Your Honor, I would ask for straight pretrial release. His last conviction was in 2013. My client is a military veteran, 19 years. So I just ask that you take all of that into consideration and place him on straight pretrial release.
Your Honor, he has a 2019 CF battery by strangulation with the same victim, and then he had a 2020 misdemeanor battery DV also with the same victim. There's just an ongoing system of violence between these two.
And I think if we issue a no contact order, that will resolve that, Your Honor.
All right, find probable cause and required pretrial release plus a $500 bond. Sir, I respect your military background, but you need to stop getting these cases. No contact with the alleged victim, separate residence. If you need a police escort,
$50.
you have the right to remain silent. Anything you do say is going to be recorded and can be played back in a court of law.
It's not about the facts of the case.
Okay? You need to speak up. I'm hard of hearing.
Not about the facts of the case.
Right.
I don't have the money right now. I just had 2 grandbabies born. I have a serious medical condition with MS. And I want to leave here and probably go to the VA hospital because my condition is getting worse at Lake Nona.
Do you have a place to go so you can leave the premises?
Yes, ma'am, I do.
All right, sir, I think it's your military background that's speaking to me the most. I'm going to go ahead and grant PTR. You see calm and respectful now. I'll grant the PTR, no contact, separate residence. If you need a police escort to get some things out of the residence, that can be provided. If you have any guns, knives, or weapons, put those in the care custody of the arresting agency within 24 hours of your release. Make sure you get back to all your court dates. And because of the priors in the seeming continuing situation with you and your wife, you know, if it weren't for your military background and your respectful attitude now, you'd be having to postpone, and you need to understand that your record is contradictory at this point.
Yes, ma'am.
Good luck.
Thank you very much.
You're welcome. Okay, is this Mr. Cesar?
Yes, ma'am.
Thank you, sir.
Put your arms down.
All right, sir, the allegation is violation of injunction. And I think this was, let's see, let me get this number on this. Case number 2021 MM 3383. And you have some history with some violence. We'll set bond, but I think it goes without saying that you can't have contact now. And if I'm remembering correctly, when I was reading between the lines, it looked like, she might have let you come over to see the kids, and then you wouldn't leave. She does not have any legal authority to allow you to come over there. All right? Yes. If she wants contact, she's going to have to tell the prosecution to set up a hearing and let the judge hear from both sides in regard to that. But now that this has happened, it probably wouldn't happen anyway. You probably wouldn't be granted contact because of the situation of not leaving and all that. You've just made it far more complicated.
Your Honor, respectfully, nowhere in the affidavit does it say the victim allowed him to come over.
No, I was reading between the lines.
Understood, Your Honor, but in the affidavit, it does not say that anywhere, and there is a valid injunction in place that he's not allowed to have contact with the victim. He is aware of that injunction, and yet he violated it. Therefore, I asked for a fairly significant bond to procure the victim's safety as well as the integrity of the court at this point as he's going against court orders.
Yeah, it's important that we make it clear that it's serious. And the reason I said I was reading between the lines is that I know these things happen and, you know, it's just implied.
I believe it does say.
And he needs to understand it doesn't matter. It doesn't matter whether she says it's okay. And we understand that you have kids over there, but the problem is you've got a criminal case pending and I'll set a bond today. If it happens again, it'll be no bond. You'll just sit there until trial. And that's the way it really works.
I'm no contact with her.
I can't hear you, but don't say
I
anything.
said I would not have no contact with her.
Okay, all right. All right, taking in consideration everything, sir, will find probable cause. We will just set bond at, frankly, $2,500. I know you've got kids and everything, but this is, it's, you know, based upon all the facts and all the circumstances, plus your prior criminal history, I think that's proportionate. No contact, separate residence. If you have any guns or weapons, put those in the care custody of the arresting law enforcement agency within 24 hours of your release. Like I said, it'll be no bond if you come back. This is just a reminder, and there's no second chance after this.
Can I ask you a question? Can I go get my vehicle if I want to go get my car?
So if you need to get anything, you can have a police escort to get your thing.
Okay, thank you.
Okay, good luck. Okay. Is this Ms. Hasib? Hasab? Thank you. So this is case number 2002-1MM3360AO. I don't see a public defender request. Oh, yeah, here it is. We'll appoint the public defender to represent you. Ma'am, they have enough information to file the charge, but you meet the pretrial release requirements. I think the state's not going to object on this based on lack of history. Am I correct?
State has no objection, Your Honor.
All right, so pretrial release means you don't have to post bond. You just keep in touch with the pretrial release office from the jail, and they'll tell you all the requirements, okay? All right, but whenever these kinds of cases are pending, you can't have any contact with the other person.
I have a question.
Don't say anything about the facts of the case unless you want it to be
No,
replayed back at your trial. And the defense wants to ask you.
Your Honor, you did give a one-time return to get any.
Well, I was getting there.
Thank you.
No contact, but one-time return with law enforcement escort to get some things. If you have any guns, knives, or weapons, put them in the care custody of arresting agency within 24 hours of your release. Make sure you come back to your court dates, and I highly recommend you talk to your lawyers so that they can be prepared. And that's it. I'm sorry, we got a lot of cases. I'm moving on.
There was a separate residences as well, correct?
Separate residence, yeah. Thank you. Mr. Johnson, correct?
Yes, ma'am.
Okay. Thank you. It's case number 21MM3374AO. We're appointing the public defender to represent you. They had enough information to file the charge of domestic battery, misdemeanor. This police report, the only thing I got was 2 sentences long, and it's a conclusory allegation.
Yes, Your Honor, I tried to reach out to Orange County Sheriff's Office this morning to try to obtain the full narrative. I believe this is just the PC statement, and it wasn't able to be released to me yet because it wasn't approved by the officer supervisor yet. So if you're not inclined to find PC based off of the sentences that we do have in the narrative, I would just ask for 24 hours.
Okay. Yes, sometimes Mr. Johnson, the police officer, doesn't like paperwork, and they just don't fill very much out. So technically speaking, it does not meet the criteria of probable cause, but the prosecutor is allowed to ask for 24 hours to get like a supplement, you know, to make the officer actually fill the paperwork out. But I don't mind looking at the release conditions anyway, so that we can establish something in case you can't get out with or without waiting 24 hours. I don't want to hold you in here for 24 hours for that. On this case, this is not a no bond situation. I am a little confused about according to the pretrial release department paperwork, it says he meets pretrial release, although he's had criminal history.
There was a new form given. He does not qualify for PTR.
Oh, okay.
He actually has a pretty significant history of DV history with the same victim as well as different victims.
Yeah. Okay, that was confusing. All right. So, sir, then, if there's no specific recommendation, I'm okay going with the pretty standard stuff, but, yeah?
Your Honor, since he has a pretty significant history, state would ask for 1,500.
100?
Yes, Your Honor.
Okay. Yeah, all right, well, so, sir, the amount she's asking for in regard to the bond, 1,500, it's not out of line. You've got some history. We're trying to be careful. We're trying to give you a message that is proportional with the impact in regard to what we see on your criminal history and our concern about safety and respect for the law. So we'll put a $1,500 bond on there. And as you probably know, because this is not your first time in court for this, it's requiring no contact, separate residence, police escort if you need to get some things out of the residence. If you have any guns, knives, or weapons, put them in the custody care of the arresting agency within 24 hours of your release. Now, she, I think, is completely blind or something, so you're not going to have contact, but she probably knows, too, that if she needs your help and wants your help, she's going to have to talk to the state attorney and get a hearing before that happens. So even if she's begging you to come back and help, you can't do that until you get before a judge and make sure it's safe. Now, you could ask the public defender to have a hearing, and they could notify her and get her opinion about whether she wants contact, but she has to let them know first if that's what she wants. And she can't give you permission to have contact.
Understand, Your Honor.
Good luck.
Thank you.
Ms. Jones? Thank you. This is case number 21MM3359AO. And we could, let's see, we can appoint the public defender, ma'am. They have enough information to file the charge of battery. It appears that you don't have any criminal history. I think this state's going to be okay with pretrial release without you having to post bond.
State has no objection, Your Honor.
Okay. And You don't live together, but if you have any things in his residence that you need to get out of his residence, you can have a police escort. And you have a child in common. So the way you would arrange visitation would be through a third party, such as one of your family members?
I mean, he picks her up from daycare on Fridays, so we don't have any contact on Fridays.
Okay, third parties, daycares, that's fine.
Mhm.
If you have any guns, knives, weapons, put those in the care of the law enforcement agency that arrested you within 30 or 24 hours of your release. Make sure you get to your court dates, and I highly recommend you talk to your public defender before court so that they can be well prepared. Luck, ma'am. Ms. Michelle? This is case number 21MM248380. Ma'am, this was an alleged violation of pretrial release condition, and it was the subject of a warrant. Did we have a public defender application on this one? Oh, she's already got the PD probably, right? You've already got the public defender? Yeah. Okay. So allegedly, I think a battery was alleged to have occurred in April.
April 11th.
Ma'am?
April 11th.
Okay, you don't have to say anything about your case because you might accidentally incriminate yourself, okay? I'm just trying to explain stuff in case, because sometimes when people get picked up on a warrant, they're really confused about what happened because it happened a month ago, you know? And at some subsequent time, it was alleged that you had contact, I guess, on April 26th. And frankly, I don't think I was able to see any paperwork on what the alleged contact was, or so that's a little bit of a problem, unless the lawyers could maybe fill it in for me. And also, I wanted to ask, because I've got a couple of papers here. One says capias, but one says violation of domestic violence injunction. Is there both or just one?
There's both, Your Honor.
Both. Okay, so there might have been a failure to appear in addition to a violation of pretrial release?
There's the bat DV that happened on 4/11.
Right.
And that is the domestic violence case. And then there's the violation that happened on the 26th.
Right. And was there something else like a failure to appear, or is there just the violation that happened on the April 26th?
I believe it's just a violation.
Okay, all right, because sometimes it comes through as a capias, but it's something else. It's just, the system calls it a capias. So I just want to make sure there wasn't a subsequent third incident like a failure to appear. Okay.
Your Honor, regarding the contact, according to Officer Junco, the defendant went to the victim's residence on April 26th of 2021. She went inside the apartment. She let herself in through the front door as she already knew the code to unlock the door. The victim approached her and asked how she got back into the residence. She was told to leave but didn't. The next door neighbor came over. There were children on the front yard. The next door neighbor notified DCF. Due to the defendant not fully closing the door when the child got outside by himself.
I'm not hearing everything, but it sounds like a contact and not an aggravated more than that.
She let herself in to the victim's residence, Your Honor.
She let herself
and did not leave when the victim asked her to leave.
All right. And did you see the notes from the first appearance information sheet where they talked to the victim? The victim said that he was going to attend IAs and wishes to have contact. So, evidently it's not an aggravated situation. as far as the
Your Honor,
bond
even if the
amount.
victim wishes to have contact, the court doesn't have to order contact.
Yeah, he's
The
not here,
victim's-
he's not here, and, so we're not gonna order contact, I'm just saying, it's a mitigator. Okay. Ma'am, it doesn't matter right now if he wants contact. If you want to have contact, talk to your public defender, get a hearing in court, but you now have a new charge for the contact, because when you left court, you were told to not have contact, and so, there's a situation that, as you see, that the prosecutor read out where, it looked like you're trying to get to that apartment or something, and that was a violation of a court order, and so that's what the new charge is. So now you got the battery, plus you got a violation by going over there. Even if the victim wants contact, he does not have the legal authority to change the court order unless he comes to court and says, Judge, please, I'm sorry it happened, I want her to get better or whatever, but I want contact now. He's got to tell the judge, and then the judge can change the contact order, and that's the only thing. So, but it's not more aggravated, it's than that, which the state read. And so I'm gonna, the typical bond I would do in one of these is just $1,500 and tell you again, no contact. And that it's a separate case, but it should be combined with the other one, and they'll deal with it all as a package, okay?
Thank you.
It's 2 counts. On the first.
15.
So this was the question I was asking,
Oh,
I
I didn't
think,
see
this state. What do you mean by 2 counts?
She has a battery DV case, Your Honor, and then she has a violation of the injunction, or violation of pretrial release.
Right, okay, because she got no bonded on the battery because of the violation of injunction, is that what happened? It is not clear from the paperwork I have, because I don't get this underlying basis. I get just, the face sheet. Okay, so I'm assuming, and correct me if I'm wrong, that because of this violation of injunction, she got no bonded on the battery. Is that what we're talking about?
I'm looking.
I get this point, I'll have to get access to the clerk's records because I need the underlying information to make
It looks like they're
an
two
evidence-based
separate-
decision.
You see it? I can't.
So does the pretrial release or the pretrial office know if this battery,
It looks like it's the same case number.
It's the same case.
It
number,
is
Your
the
Honor,
same
but
case
it's,
number.
2 different warrants.
That's what we have, yeah, so I'm confused. I don't know.
So,
what happened? Yeah, probably 2 people went to the judge, basically, or handed the judge 2 pieces of paper, one on the battery violation. Well, it's basically, I think she's sort of getting, without more information, the only finding that I think is logical right now is that she got hit with 2 warrants for the same conduct, I think. So let's put, instead of $1,500 on one, let's put $750 on each. So it adds up to $1,500, which would be about the standard, I think, for going back and having contact with a person after the judge told you not to. Well, we got to do something. We can't just say it's okay,
I understand.
right? Make sure you make all your court dates, talk to your lawyer so they can be prepared.
Your Honor, did you order no contact separate residences? When
Yeah, I
returned?
did. I told her several times in different ways. No contact. If that was ambiguous, no contact. All right? Okay. Aylin Nunez Franco, thank you. That's you, right?
Yeah.
Okay, thanks. It's case number 21MM 303AW. Ma'am, they had enough information to file a charge called battery, which is a misdemeanor. We don't have the other party here in court. So we're going to have to require no contact for now, which is awkward because you traveled here from on vacation, and you're probably going back to Maryland. But they have enough information to file the charge. You now have a case pending in Florida. You're going to have to come back for it. According to what you wrote on your public defender request, you could get the public defender appointed. So keep in contact with them in case they might save you a court date or two, when they can represent you. If they've had good contact, if they don't have good contact, they just say, Judge, I don't know. And then a warrant gets issued if you don't come back.
Okay.
Okay. So talk to them. We're going to require no contact, separate residence. If you need a police escort to get things out of the residence, I don't have any jurisdiction in Maryland. I guess I can put it on the paperwork, but I don't have any jurisdiction in Maryland. You have one child in common. So what we order in those, in order to implement a no contact order, you would exchange custody and visitation through a third party such as a family member, or like one lady just said a little while ago, well, you could do it, just drop off and pick up at daycare, but still, even to arrange that, you have to do that through a third party, like a family member, to say, oh, who's going to pick her up today, kind of stuff. If you have any guns, knives, or weapons, put those in the care and custody of your arresting law enforcement agency within 24 hours of your release. Now, she qualifies for PTR, and there's no prohibition for her going back to Maryland, correct? As long as I order that?
Yes, Your Honor.
Any objections, State?
No, Your Honor.
Okay, we're not going to try to keep you here, but just be aware you have to come back for your court dates when required, because otherwise you have a warrant out in Florida.
I understand.
Okay. Good luck. Okay. Ms. Taylor? Thank you. This is case number. We'll appoint the public defender to represent you, and it's case number 2384 AO. And they had enough information to file the charge, no history. State's probably not going to object. Oh, was there a pretrial release on this or not? You probably didn't have all the information when the first appearance information sheet was made, but it appears like she's got no history, so.
Oh, yeah, she could qualify, Your Honor.
She does? Right, okay. All right, so I don't see the state objecting because you don't have any history. So, ma'am, you can get out without post and bond, but then you have to just keep in touch with the pretrial release office, and they will tell you what all the requirements for keeping in touch with them are. Okay? And while the case is going on, unless or until your mom and dad say, I forget if they're both alleged victims or one of them is alleged victim, they would have to come to court and tell the judge that they want contact if there's to be any contact. But until then, they don't have the ability to tell you to just, have contact. It has to be through the judge.
Okay, so they have my children right now. How would I get them back?
Well, with a third party, like another family member or trusted family friend. And it's not easy because we're going to tell you don't have even any indirect contact. That means like not calling them, not texting them, and, having to go through a friend and that sort of thing.
Okay.
And if you need to get some things out of the residence, we'll allow you a one-time police escort to do that. And if you have any guns, knives, or weapons, those have to be put in the care and custody of the arresting law enforcement agency within 24 hours of your arrest. You've got a lawyer. You need to let them get in touch with them before court so they can represent you and make all your court dates. Failure to appear in court results in a warrant for your arrest, and so does contact that's not authorized by the court with the alleged victim.
Your Honor, you said one-time return. However, I don't believe you said that she must maintain a separate residence.
All right, separate residence. Thank you. Mr. Wilson?
Yes, ma'am.
Thank you, sir. It's case number 21MM336480. Public defenders appointed. They had enough information to file a battery charge. Looks like no prior criminal history. Does he qualify for pretrial release? Yeah, he does. Okay. If the state doesn't object, I'll order pretrial release. The paperwork says that you live together. It also says that when the pretrial release department contacted the alleged victim, that she wants to have contact, but
It's a male.
she's not here, so we can't.
It's a male, and yes, he's not here.
Oh, I'm sorry. I didn't put that part down
It's a male.
on my notes. I put my little, like,
We were in a romantic relationship for 2 years.
okay, you don't have to say anything about your case because it could be played back at trial, okay? So your lawyer doesn't want you to say anything. But, okay, and I'm sorry that I misinterpreted that. What happens is I read a whole stack of stuff in the morning and I make myself a cheat sheet and I didn't put that down because, to be honest with you, that doesn't make any big impression on me one way or another. I don't, care who people love. So I just didn't put it down. So, but anyway, even if he wants contact, he told this office that he wants the contact, but he didn't show up, but he has to be in court and tell the judge he wants contact.
Yeah.
We can't order contact until he comes to court. And you can't call him up and tell him to go to court because we're telling you not to have contact. But you can tell your lawyer that you want to have a hearing on that so that a judge can hear from both parties and determine it's safe. Until then, separate residence. You can have a police escort to get some things out of the residence if that's what needs to happen in order for you to obey the no contact order. And if you have any guns, knives, or weapons, put those in the care and custody of the arresting law enforcement agency within 24 hours of your release. You can't have any weapons while you're out on release on a domestic battery. But pretrial release means you just follow the rules and keep in contact with them, and you don't have to postpone.
Your Honor, are you ordering separate residences and a one-time return?
I did. I know you're used to me leaving stuff out, but I'm actually hitting most of the items today. The clerk says, yeah, I'm doing it. So. Might have taken an old judge a couple of days to hit this stride, but we're finally getting there, I think. All right, thank you. Is this Mr. DeRozier? Thank you, sir. Okay, so we have case numbers 21 CT 1778, 1779, 1780. We can, is there a public defender application?
I believe we're already appointed, Your Honor.
Previously appointed, okay, thank you. So, it looks like a failure to appear
Yes, Your Honor.
on an attaching tag, DUI, those cases, and he would have, was he out on bond for?
Your Honor, there's also a Dwellis as well, 21 C.
Dwellis, okay.
1779.
And he was out on bond for a murder charge?
Yes, Your Honor, he's been found incompetent to proceed in the murder charge, so I would just ask that you take no action. It's been open since 2018, and he's been deemed incompetent to proceed.
All right. All right, state, so he failed appearance of traffic charges while he's out on bond, but found incompetent on a murder charge, so.
Your Honor, in regards to the failures to appear, I say you just hold him no bond. I believe that's how they came in.
That I leave it at no bond?
Yes, Your Honor. On a failure to appear, that's generally how the warrants come in.
On misdemeanor cases?
Yes, Your Honor.
Really?
I mean, some do come in at a bond, but if they came in at no bond, I'm thinking it's supposed to stay at a no bond
At no bond, Your Honor.
on an FTA.
I didn't hear what you,
They
the last statement that,
They usually come in at a bond, but when they come in at a no bond on the FTA, I'm thinking they supposed to stay at a no bond.
that you think that's what the judge wants.
Yes, Your Honor.
Well, okay. But we have the public defender appointed, okay. Yeah. I don't know, because some judges, they just hardly look at stuff and they, I don't know what the judge wants, but I do know that he's represented and we have not been throwing a whole lot of things into the lap of the public defender. So let's go with the suggestion by jail staff and the state to keep him in jail, but get him over there to the judge and who can present the finding of incompetency on the other case and let that judge figure out what they're going to do. And I think I will go along with the suggestion of not touching the murder charge because they've already found him incompetent. That judge doesn't need to be dealing with a traffic case. Sir, we're going to put you in the capable hands of the lawyers and let them get you a hearing in regard to the bond situation on your traffic charges.
I already let the attorney know that's assigned to your case, so I emailed him to let him know so he can get you a hearing.
You probably want to get a family member to attend your hearing so they can assure the judge that you're going to follow up and deal with your court dates.
I went to court the first time. They had canceled it, and they were supposed to send us,
You had cancer,
no, they had canceled it.
canceled it. Okay, so it was confusing.
Yeah, so.
They're gonna ask the judge for a hearing, and normally you should be able to get one within 3 days. Okay. What's next, the pleables or,
Arraignment,
okay. Are you wait-
Johnston is medical.
Oh, medical, okay. And it's only one, right?
2 more.
Okay, all right, got it. So he's been in for 25 days and he's already got a public defender, so you're gonna waive arraignment?
Yes, Your Honor, I'll waive the appearance and enter a plea of not guilty.
Thank you.
Division 63, pretrial conference day will be June 10th at 1 p.m., room 12C.
And that's 2021 MM 3275. Thank you. All right, so Justin LeBoy, 2020 MM 5140.
He refused court.
Okay,
Your Honor, I'll waive the appearance and enter a plea of not guilty.
thank you.
Division 84, pretrial conference date is June 14th at 9 a.m., courtroom 4B.
All right, Luis Perez,
He's medical.
21 MM 2456 BO.
I'll waive the appearance and enter a plea of not guilty, Your Honor.
All right, thank you.
Division 82, pretrial conference date is June 14th at 10:30 a.m., courtroom 10B.
Thank you. All right, is this Mr.
Campbell, Phyllis, mental health.
Okay. All right, so we're not resetting these anymore? That's case number 2002-1MM.
You said Campbell?
337.
Misdemeanor playable.
Payables.
Oh, I'll waive the appearance.
Okay. Let's appoint the public defender. It's going to Division 61. The allegation is trespass. And we'll find probable cause, leave the bond at,
They would ask for no return to the area, Your Honor.
250 and no return to the place of the incident. Thank you. Is this Mr. Carl Kendall? Claudel?
Yes, Your Honor.
Okay. It's case number 21MM336880. And if you need the public defender can be appointed, sir.
Just a moment.
Yeah.
Okay. Your Honor, I believe the offer from the state is an adjudication of guilt, credit time served, and no return. I don't know what ATW is.
To PNC Southside Shopping Center at 2823 South Orange Avenue, and to abide by the trespass warning.
And then for the alcoholic beverage open container, it's a withhold of adjudication and credit time served. And Mr. Caudill would like to accept the state's offer today.
Okay. All right, sir. If you wish to accept the officer, go ahead and raise your right hand to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth? All right. You can put your hand down. Sir, you'll be giving up all the rights on your plea form. You won't have a trial. You won't have a defense. Nobody will have to prove it beyond a reasonable doubt. And you won't have any rights to appeal. Do you understand all those rights?
Yes.
And you're willing to give up those rights in order to finish your case today? Any questions? Okay. You're on probation for anything, it'll violate your probation. Immigration consequences if you're not an American citizen. But it does appear that you are alert and intelligent, entering a plea of no contest in a free and voluntary manner. There's a factual basis for both charges. And so we'll accept your plea of no contest, find adjudicate you guilty of trespass after warning. He was out on bond for a petty theft also. You guys just want to move past all that because,
I would just ask because he's resolving the case today, Your Honor.
oh, that's right.
No
State's been
action.
doing that, right? Okay. Okay. So we'll find adjudicate you guilty of trespass, tell you not to go back to that, I wrote it down here, but PNC. Where'd I put that? At 2823 South Orange Avenue. And give you credit for time served, release you as that charge. As to the open container, withhold of adjudication, credit for time served, release you as that charge. We always apply the court costs, which as you know are around $300 or something, and we give you a year to pay before we suspend your license again. That's it for now. Good luck. Anthony Corcel?
Yes, ma'am.
Thank you, sir. This is case number 21MM337980, also out on ROR in 21CF3568, which was possession of methamphetamine, burglary of a vehicle. The new charge is an alleged petty theft in Division 85. Public defender can be appointed. Were counsel trying to resolve this one?
No, Your Honor, I believe it may be enhanceable.
Okay. Sir, in regard to theft charges that you might have pled out to before, hopefully the judges told you that when you get petty theft convictions, they can be used to upgrade subsequent petty theft cases up to and including felonies. And so there does come a point where you start potentially going to prison. People have and do go to prison on petty thefts if that keeps happening. And so the state wants to wait and see if it's to that point or not, or if they should start actually, doing some jail time to try to deter it from happening, assuming that, when the penalties go up, at some point, an individual might decide to do something else instead of do that to get stuff. So we'll appoint the public defender to represent you. We won't resolve it today. It does appear that they have enough information to file the charge. And it's at the normal bond level of 500 on this. Let's see what he's out on bond for. Possession of meth. So is he out on bond or is he out on ROR? Because I have two different.
ROR, Your Honor.
Oh, he's on ROR. Okay. And the original bond amount would have been 5,000, I think.
35 on the Burke conveyance and 15 on the meth.
And was the ROR pursuant to a 33-day motion or because the trial judge thought he'd spent enough time in jail or something?
33-day motion.
Was it subsequently filed?
Yes, Your Honor. Oh, no, Your Honor. It was not.
It has not been filed.
No, Your Honor.
All right, well, I appreciate your being able to tell me all that stuff. If it hasn't been filed, I don't want to revoke his bond. I'm just going to take no action. All right,
They would ask for a no return, Your Honor, to the Dick's Sporting Goods.
now return to that sporting goods place, sir. You're welcome.
You stayed the bond at 500?
Yeah. Okay, so, Mr. Hunter, case number 3376 AO. It looks like you might have been out on bond for a petty theft and a trespass, which might have happened on different occasions according to the case numbers. And the new charge is a trespass. Okay. All right, and if you need a public defender, we can appoint one for you, sir. It's an alleged trespass, and I need to look at it real quick.
Your Honor, I believe the state is offering an adjudication of guilt, credit time served, and no return in order to resolve the case today. And he would like to, Mr. Hunter would like to accept that offer.
He's out on bond for a trespass,
Yes.
and they say that he keeps going back there.
Yes, I think the issue, Your Honor, was that we would have resolved these cases earlier. However, he was being evaluated for competency concerns.
Oh, was this a while back? 18th of May?
So we had him evaluated for competency issues.
Oh, the ones he's out on bond for?
So that's why they weren't resolved previously.
Oh, so you know the guy?
The out on bond trespass is a true victim case, so there was never an offer conveyed on that one.
Is it what?
True victim case, Your Honor. He trespassed at someone's residence.
I can't hear about half
It's a true
vic-
victim case, so they never made an offer on that one, Your Honor.
Well,
At
yeah, okay, I mean, I'm not saying that, I mean, all right, so you think he has competency problems, and.
That-
but
yeah, that
he
was
still
the-
keeps going back to places where they don't want him, and
Yes. Let me just double-
does he have anybody that he lives with that can, help him stop doing this?
I got my mom.
let me just double check.
Because I'm fixing to offer him about 10 days to drive home the point that he's got a criminal record for trespass, and the circumstances that they wrote about on the page are like, the guy needs to learn. Unless you convince me that he's just, well, if he's incompetent, he can't enter a plea anyway, but, at some point, we should be telling him to not continue to trespass unless he's too incompetent to understand a plea.
I'm just double checking, Your Honor.
Okay. I mean, I used to give people some jail time when I was in this department, like the guy that we just time served, it was.
There's some mental health issues, Your Honor, but he has not been found.
Incompetent.
He had an evaluation done, but he does suffer from mental health issues.
Well, he looks like he's alert and intelligent at the
He is.
moment. I mean, he responded right away. He knew what the question was. He gave an intelligent response. Sir, I could, I'm just looking for a way to try to get through to you, and I don't assume that 10 days is going to do it, but I'll go ahead and make an offer. I won't revoke you on the other charges that you're out on bond for, including trespass, but I'll make you an offer of 10 days instead of, time served, and you've served too. But I just think that the message needs to be there, because not only did you go back, you've been going back, and they are tired of you, and then you were like giving a lot of attitude to the cop. And frankly, I just think 10 days is appropriate based upon your record and all the circumstances. So
Can I have
that's
just
fine.
a moment to discuss it with
Yeah.
him, Your Honor?
That's what I'm looking at. I won't revoke you on the other ones, but they'll see that you pled to it again, so you're getting to the point where you might have to start doing more than time served occasionally.
Okay, Your Honor. He would like to accept the offer.
All right, then. Would you raise your right hand to be sworn in, sir? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Now, I do need to just make sure, Mr. Hunter, because they've had some considerations or concerns about your capacity or your mental state, which, I think all of us are a little bit, have issues, but it's just a matter of degree. But it seems like you're alert and you're intelligent and you know what's going on here. Am I correct? But
Little bit, ma'am.
a little bit?
Yes, ma'am.
Well, let me ask you this. In good faith, should I find that you're clear enough to be able to know what you're doing here today? Because in good faith, I have to be able to make that decision. That's a yes with a nodding of the head for the record, because he's not sure if he, But if you want to take the deal, I have to make that decision.
Yes.
Okay, all right. I think you do. I think you really know what's going on, even if you have some issues. And you understand the rights on the plea form that you give up when you enter a plea?
Yes, ma'am.
So you won't have a trial, you won't have a defense, nobody will have to prove it to a jury of 6 people that you were trespassing with attitude. You're not charged with trespassing with attitude.
Okay.
I'm just trying to talk to you about it. But they won't have to prove that you trespassed, and the jury won't have to all be unanimous that they think it was proven before you can be found guilty. Do you understand that?
Yes, ma'am.
Okay. Now, if you're on probation for anything, this would revoke your probation. And if you're not an American citizen, that is a problem when you enter a plea on a criminal charge. You understand that?
Yes, ma'am.
Okay. I believe, sir, that you are alert, that you are intelligent, that you know what you're doing, and that you're doing this of your own free will because you figure that the judge isn't going to change your mind, and that's what you're going to have to deal with. So I'll accept your plea of no contest as being freely and voluntarily entered, find a fact your basis, send you to 10 days with credit with probably 2, and tell you not to go back there again. I feel bad for these people when I let them out time served, and they have had trouble with you before. So we will give you the 10 days with credit for 2 and charge you the court costs, give you a year to pay those. I'm not going to revoke the other cases. I'm going to take no action, and I'm going to say the reason why is because you entered a plea on a new charge, which I'm just going to take that into consideration.
That was an adjudication, Your Honor, and there was a no contact or no
Yes.
return.
Thank you. Adjudication, no contact, don't go back there, at least while I'm on the bench for the next week and a half, because I might remember, okay? Where do I put, okay, no capias. Do I give this to you or to the clerk?
The clerk.
Thank you. Okay. Is this
Dormill,
Dormel?
he's medical, Your Honor.
Okay. This, does this person already have a PD?
Yes, Your Honor, on the other cases.
Oh, the one that he's out on bond for?
Yes, Your Honor.
Okay, and there's a new one, right? Or is that the, that's the arrest warrant for battery. The bond is 500 on that. It was alleged to have occurred on May 16.
Your Honor, on the out on bond cases, I would ask that you take no action. He was evaluated and found incompetent to proceed. And so I'll just ask that you take no action.
Has he formally been found incompetent by the court, or was it one?
He was last
Eval.
evaluated December 16th of 2020.
So,
He had a new evaluation.
so you're saying that the evaluation said he was incompetent, but he's not been adjudicated incompetent?
He has been adjudicated incompetent, Your Honor. I believe the state was asking if it was just a motion to continue the incompetence over into a new case, but he was actually evaluated. He had a new evaluation December 16th of 2020, where he was deemed incompetent to proceed.
All right. So he's out on drug paraphernalia, trespass, battery, resisting, okay? So you're asking me just to stay the bond on the 500 and take no action on the ones he's out on bond for?
Yes, Your Honor.
All right, stay, he's probably not gonna get out because he's just, doesn't have it together enough. So we'll do that, appoint the public defender and let them bring them all back to
He
the
would ask
judge.
for no contact with victim or witnesses on his new case.
So ordered. Is this Erica Griffin? Okay, thank you. The case number 20MM 0AO. So, coming back on a failure to appear, Division 61, was a public defender previously appointed on that? There was
Yes, Your
a
Honor.
false information or ID to law enforcement and a driving license suspended. And the bond on the failure to appear for count 1 is $750. The bond on count 2 is $100.
Yes, Your Honor. The state is offering an adjudication of guilt, credit time served on both charges. I did speak to Ms. Griffin, and she would like to accept the state's offer here today.
All right, well, Ms. Griffin, on the driving license suspended, I guess, I'm just guessing, looking at your history, that, they suspended you a while back because of failure to pay fines on your criminal charges. You get the drug charges, you lose your license, and you give up. So time served might be good at this point because you've already got several driving license suspended. And, these can be enhanced to become felonies. And some people actually have gone to prison on driving with license suspended cases when they're driving on a 5-year revocation. And given the number of ones that I'm seeing on the pretrial first appearance sheet, I would guess that you could very well be triggering a 5-year revocation if you have not already. Do you know what I'm talking about?
Yes, ma'am.
You get 3 dwellises and you get a 5-year revocation. If the 3 dwellises within 5 years, and you get a 5-year revocation. So my guess, without having looked at your driving record and studied it very well, is that this was probably going to tip you over to the 5-year revocation.
I haven't been.
No, I don't,
Maybe you're working on your license.
Yes.
Well, okay, if you're working on your license, because that's why you had a status hearing, and you were starting to unravel the situation, you got a $750 and $100, you can't call somebody, get it out, get you, no, huh?
No, ma'am. I'd rather do the court costs and everything.
All right, even knowing that it might trigger a 5-year revocation,
Yes, ma'am.
all right?
yes, I went over all of that, Your Honor.
Yeah, I get that you did, but I have to do it for the record, because
Yes,
if
Your
it
Honor.
happens and she gets picked up on a felony, then they're gonna look to see if they can open this up, and so I have to make sure that she knows,
I understand.
right? Okay.
Yes, ma'am.
Okay. All right, if you want to do that, then raise your right hand to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Did you have a chance to read that plea form, or you are familiar with it from before?
Yes, ma'am.
Okay. And you understand you're giving up the right to have a trial or a defense, or have the lawyer check out your case for technical defects in the state's evidence?
Yes, ma'am.
State won't have to prove it beyond a reasonable doubt to a jury of 6 people, all of whom would have to be unanimous that the state proved every element of the charge.
I understand.
And you won't have much of anything to appeal. If you were on probation, this will violate your probation. You understood you're not on probation, okay? And if you're not an American citizen, any of these criminal charges can result in deportation. Any questions?
No, ma'am.
Satisfied with your lawyer?
Yes, ma'am.
Okay. I think that's a minimally valid plea, colloquy, even though it's fast. So I'm going to go ahead and find that you're alert, intelligent, entering a plea of no contest in a free and voluntary manner on the count 1, providing false ID to law enforcement, and count 2, driving with license suspended. I don't have the facts in the original file, so does the defense stipulate his factual basis for the record?
Yes, Your Honor, for the purposes of the plea.
For the purposes of a plea. So we'll accept your plea, find a factual basis based on the stipulation, adjudicate you guilty on both charges, false ID and driving with license suspended. Sentence you to the time you've already served.
4 days.
4, okay? Release you as of this charge, impose the court costs. There's probably at least a $50 public defender fee in there, and we'll just give you a year to work on that along with everything else. You're working on to try to unravel your license. Good luck.
Thank you.
You're welcome. All right, is this Mr. Travis Bridges? Okay, sir, thank you. We have case number 21MM1333AO, and I think you might be getting held for something else, but we have today to notify you of a violation of probation. It's alleged that you violated probation by not reporting to your intake appointment.
Yes, ma'am. But I came
So,
to,
well, wait a minute. You can get the public defender on this. Did we try to resolve these at this stage or not?
No, Your Honor.
Okay, so be careful. What we sign this as. And, okay, I remember when the probation officer handed this to me yesterday really fast while I was on the bench. So it wasn't like I could look up your criminal back record or the, the case or anything, but I asked her, I said, what does this judge do on VOPs? And she said, he does no bond, Judge. And so I took her advice because she probably knows what Judge Jewett does, because I think he's been a judge for a while now, 20 years or 15 at least. So that's why I put that. And she probably is right. And so that means that he probably wants you to go downtown and look him in the eye about why you didn't show up. So I'll appoint a public defender and tell you to go downtown to see Judge Jewett. Hopefully your lawyer can get you faster than the regular procedure, which could take a week or two, unless they try to move it up.
So for the record, that's being held no bond, Your Honor.
Yep. Good luck, sir.
all right, thank you.
You're welcome. You too. Is this Mr. Fields?
Yes, ma'am.
Thank you, sir. Case number is let's see, what is this case number? 21MO587AO, I think. Division 85 is called Possession of Alcoholic Beverages. And if you want a public defender, just let us know, sir. But it looks like they might have enough information to file the charge. And so they said they found a gram of cannabis, but and then they said that it was to be placed into evidence for destruction. So I don't know for sure if that means that they could pick up a separate charge or if they were going to throw it away.
Your Honor, it's not filed. We're not going on it.
You're not? Okay. It's kind of weird. And he mentions it, and he just, oh, would he possibly throw away 1 gram because it's so hard to prove now because FDLE isn't giving you the testing and it's just gotten to that point?
Your Honor, he mentions it in the report just for adequate keeping, but yes, they know the policies of our office regarding the cannabis. So I believe that agencies are also creating their own policies as well.
All right.
Just for judicial efficiency.
All right, so it's easier for them to prove an open container now than cannabis, so they're just charging it with open container. Okay.
Yes, Your Honor, and I believe the offer is a withhold of adjudication, credit time served. Mr. Fields would like to accept the state's offer.
Okay. Sir, raise your right hand if you want to be sworn in to plead no contest. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down, sir. Sir, did you understand you'd be giving up all the rights on your plea form? You won't have a trial, you won't have a defense, nobody will have to prove beyond a reasonable doubt to a jury that you had an open container charge?
Yes, Your Honor.
If you were on probation, it would violate your probation. If you're not an American citizen, you could get deported. Any questions about that?
No, ma'am.
Doing this of your own free will?
Yes, ma'am.
Okay. It appears that you are alert, intelligent, not under the influence of anything. There's a factual basis that you're doing this of your own free will. I accept your plea of no contest. Withhold adjudication, I think it was?
Yes, Your Honor.
All right, credit for probably 2 days. 2?
Yes.
Time served, release you as this charge. We charge you the court costs. We give you a year to pay in case you're trying to work it out so that they don't suspend your license. On that. Thank you.
Thank you.
You're welcome. This might be 21MO588AO. Is this Mr. Billy Higdon?
Yes.
Yes, okay. And it's a Division 63 case in open container. You can get the public defender if you need the public defender, sir.
Yes, Your Honor, the state is offering a withhold of adjudication credit time served, and Mr. Higdon would like to accept the state's offer here today.
Okay. All right, sir, do you wish to resolve the case?
Yes. Okay.
Okay. You may raise your right hand to be sworn in to tell the truth. Can you hear?
No, I can't, Judge.
Okay. Can you hear me now?
I can.
Okay. You can raise your right hand.
Yes.
Any
In
hand.
the hearing device.
You really can't hear. Wow. It was too much rock and roll music in the day. He and I are the same age.
It's not working.
Can you say something, Your Honor?
Can you hear now?
Yes, I heard that.
Okay. All right. Would you raise your right hand to be sworn in?
Yes. Oh,
Okay.
crazy. Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. You could put your hand down. Okay. All right, sir, it's a open container charge. Do you know what you're charged with?
I didn't hear a word, no.
You can't hear? Is that thing not working?
It's like on and off. It isn't you.
Oh,
I heard off.
maybe I should speak really loud.
Now you are.
Okay. It's an open container charge, understood?
Yes, Judge.
Okay. And you want to take time served?
Yes, Judge.
Okay. Did you read the plea form or you have seen it before?
I did. I read it.
Okay. Are you willing to give up the rights on that plea form?
Yes.
You won't have a trial? You won't have a defense? Nobody will have to prove it to a jury of 6 people, all of whom would have to be convinced that it was proven. You understand?
Yes.
If you were on probation, this would violate probation, understood?
Yes.
Any questions?
No.
All right. Sir, I will find that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner. There's a factual basis. I'll accept your plea. I forgot, was this a withhold or a conviction?
Withhold, Your Honor.
Withhold, okay. On the charge of possession of alcoholic beverage, sentence you to the, probably 2 days?
2 days.
Time served, release you as to this charge. We do charge you the court costs and give you a year to pay in case you need to make partial payments.
Okay, thank you, Judge. Also, I have something to make you aware of.
You want to tell the lawyer first?
I did.
He did, Your Honor. He would like to address the court.
Okay.
In booking, you have people stealing money from the inmates. Last week I was here. They got me for $14. Not a lot of money, but I was told, oh, the officer miscounted. He didn't. I was with him. We counted it together. So they're taking advantage, and God knows how much money they're making. You can figure it up, I did. But anyway, I wanted to make you aware of that.
All right. I can't tell you that I'm going to take any action because I'm just a temporary judge here. But you said it for the record in case anybody, these proceedings are monitored. And it may well be that somebody in jail administration could be notified.
I would like to write a letter to Judge Adams and let her know.
Okay.
Okay.
Whatever you write is a public record, sir, and you're entitled to do that.
Okay.
All right, well, good luck to you.
Okay, thank you.
You're welcome. Okay. All right, is this Mr. Johnson?
Yes, ma'am.
All right, thank you, sir. 21 MO 589 AO, Division 84. You can get the public defender if you need their services beyond today's date. The allegation is disorderly conduct.
And, Your Honor, the state is offering a withhold of adjudication credit time served. And Mr. Johnson would like to accept the state's offer here today.
Oh, okay. All right. And are you all getting rid of the first appearance detainer as a result of him resolving the case? Because he was out on an aggravated assault with a weapon charge.
I don't know why that's there.
She's looking at it, I think. Might be looking it up. We'll give her just a minute. Mr. Johnson, I will admit it gives me a little bit of pause too, you know. I'll probably, certainly take into consideration their recommendations. I do worry a little bit about panhandling when there's any kind of violent health history.
Yes, Your Honor. I do believe William Dodson is an AKA for William Johnson.
Yeah, he's got a few.
Yes, Your Honor. This is otherwise a city ordinance case.
Yeah.
If you are inclined to revoke his ag assault, I just ask that you set a new bond.
And Your Honor, I would just ask that since he's resolving this case, that you take no action on the out on bond, because he's resolving the disorderly conduct today.
I'm just looking at his criminal history. Does anybody know anything about it, what kind of weapon it was allegedly? Oh, gosh, she's a ROR'd on that, which probably was a 33-day motion then, right? Would be my guess, because otherwise, he's not going to be ROR'd on an ag assault with a weapon with a criminal history.
Yes, Your Honor, and I ask that you take that into consideration.
Did anybody check that? I'm just guessing, but I think that's probable.
When I tried to pull it up, I couldn't. That's why maybe it's the different names in my system. I couldn't find it.
Your Honor, there was a notice on filing. He was released to it, and then we filed an information. And the underlying facts of that case is the defendant approached Crest Chop House where customers were enjoying the patio area. He asked customers for money. The victim told him no. He got upset, yelled profanities, returned with a metal pipe, and charged the victim. That was at Crest Chop House. So the deadly weapon is a metal pipe, and he was asking for money.
All right. All right. Thank you.
But the information has been filed.
All right. So what probably happened, Mr. Johnson?
Excuse me, ma'am?
What probably happened, so the one that you're out on bond on is, can you hear me?
Yeah, I can hear you.
Is the one where allegedly you were aggressively panhandling.
Yeah.
And you don't have to say anything about that case because it's a felony.
Okay.
it's with a weapon, you have a criminal history, you could go to jail for quite a while on that.
Yes.
And here's my situation. Panhandling is a real problem.
Yes, it is.
Now, don't say anything about your case. I don't mind giving you time served on the new one, but I'm gonna reset some kind of bond on the old one because you're not allowed to keep doing this when you're out on bond, number one. Number two, an aggressive panhandling with a weapon is a significant problem for the safety and welfare and also economic well-being of this community. One of the reasons why downtown has suffered is because of aggressive, threatening panhandling. It's wrong. You got released on it because probably, I'm guessing, but it's a very educated guess, they had not yet received contact from the people that allegedly said you were threatening them. Then they later filed. So I'm guessing that they got a witness. And I'm guessing that you might actually have to pay a penalty on it based upon your criminal history, unless they're so crowded in criminal court they can't deal with stuff and they're just throwing them away practically, which is quite possible with the backlog. But
And Your Honor, normally,
I'm not inclined to just leave it at ROR when you're back out panhandling. Especially when you supposedly confronted the people allegedly with a metal pipe. What was the original bond before it got ROR'd for the 33-day motion?
It was $1,500.
1,500?
Yes, Your Honor.
So regardless of whether you plead, I'm going to revoke the ROR and put it back at 1,500 since now they filed the charge. You put yourself in that position. You gave it back to the judge, is what happened. Did you have move-ups? The clerk was wondering.
Are we skipping Maldonado because of the interpreter being on lunch?
You don't, yeah,
We might not get there for a little while anyway. Maldonado with an M? Yeah,
right.
it'll take us a little while. Okay, so
Move ups?
are we, do you have a move-up or?
Yes.
Okay, the clerk thinks that's Albers and Barnes. Okay. All right. Is this Mr. Albers? Okay, sir. You have a case that we're letting you know about today, and it's being added on to some other things that you already have. And sometimes that happens when you've got some things out there. This was alleged to have occurred on January 21st, and it's case number 2002-1CF5806 AO. It's going to Division 14. So another judge signed the warrant, sir, and it's alleged that you introduced contraband into a county facility with a bond of $1,000, that there was a sale and delivery of controlled substance with a bond of $4,000.
Sell and deliver?
Well, let me mention this. And there's another bond of $500 on unlawful use of two-way communication device. You know, we could look at the charges a little closer and the bonds. However, you've got some other things going on. So what really happens is eventually they take them down to one judge. Basically, your public defender has to batch them all together, get them in front of one judge, and they look at them as a package and trying to figure out, you know, what's going on with Mr. Albers, you know, what do we need to do? And it's just all kind of a package. So I don't want to touch the bonds because I know they're going to do it downtown anyway. All right?
I have a question.
You have the right to remain silent. Anything you do say could be used against you in a court of law because everything's being recorded. Your lawyer wants to talk to you about that. Did we got to appoint that public defender on this because he's got a public defender on the other stuff probably. All right. Okay, all right, still talking? All right.
Yes.
Where was-
500. 000.
Is this Mr. Barnes?
Yes, ma'am.
Okay, sir. We have an out-of-county warrant out of Pasco County, 2021 CF, 2017 CFAX, yes, I guess, which is no bond. It's an alleged murder in the first degree, sir. And there's nothing I can do with that other than to let them come get you, which won't be very long, but it's at no bond and it's Pasco County. All right, and at that point, they will talk to you about getting a public defender or whatever you need.
Yes, ma'am. Thank you.
You're welcome.
Did you appoint us, Your Honor?
I'm assuming, okay, do you want to be appointed? Because if it takes a couple days, you
Only
want to
because-
just be appointed for that reason?
Only because it's set at no bond, Your Honor. Since it's at no bond, we want to make sure that if he sits here and Pasco happens to not come
Okay,
and get him.
good, no problem. Point the public defender for that.
Thank you.
All right. All right, is this Mr. Errol?
Yes, ma'am.
Sir?
More.
I didn't hear that last piece, but, sir, you got, new case is 21 CF 5846 Division 14, and we can appoint the public defender on that. It's an alleged trespass of occupied structure being the 7-Eleven, the bond of 100. And the petty theft, I think they are considering filing it as a felony because of some priors, and so the bond is 1,000 on that. And there are a couple of cases that he was released on unrecognizance. Are you looking? Oh, you're not Mr. Errol?
No, I'm not Errol. I'm Hank Elmore.
Elmore, oh, I can understand why you thought that that's what I said. Elmore. Oh, is he a move up? Oh, okay, sorry. I don't think he's. Oh, it is, okay. Yeah, I can find that. He's just in the E-L-M-O-R-E. Okay, let's transition to that. All right, are you ready for that? Okay, so we have case number 2021 CF 5840 AO in Division 11. We can appoint the public defender to represent you, sir, and there was probable cause in regard to 4 counts, and I'm willing to leave the bonds as they are, given all the circumstances. Count 1, burglary of occupied vehicle, basically, bond at $5,000. Count 2, grand theft 3rd degree, bond at $150. Count 3, possession of controlled substance in an unapproved container, bond is 100, and count 4, resisting without violence, the bond is 100. We'll appoint the public defender, and wish you good luck.
Your Honor, state would request no contact with the victims or witnesses.
All right, no contact with the victim or witnesses.
Okay, so what is, to get out, I have to bail out?
Yes, sir.
What's that?
Yes, sir.
Okay, and how much is the bail to get out?
So about 5,350.
So it's a,
So are we back to the regular docket? Are we on the regular docket?
Yes, ma'am.
Thanks a lot. Okay. Mr. Errol? Okay.
Yes, Your Honor.
All right, sir, we have for you case number 21 CF 5846. It's going to Division 14. We can appoint the public defender to represent you. They had enough information to file the charges and stay the bond at $100 on the trespass of occupied structure, the 7-Eleven, $1,000 on the petty theft because they might file it as a felony because of the priors. You can get upgraded to the felony. And there were a couple of cases for which you were out on bond, that being 2021 CF 3244 and 2021 CF 3655. They were not filed yet. He got let out on a ROR, although I did look up, well, I was able to look up one, and they supposedly have him on video committing a burglary at Armando's in Winter Park, but the state has not seen fit to file it yet. So I'm reluctant to
And because of that, Your Honor,
revoke his bond, even because the state hasn't filed it.
I would ask that you take no action, being that they're not filed on the charge, Your Honor.
I don't know why they haven't filed it. Because a third grader could prove that if it's on video. Because it looked like you were really shopping in Armando's. So you just were in there for a while, you know, and then you were taking this and you were taking that, you were taking all the other things. But I'm not going to jack you up on it. I'm just going to leave the bonds where they are because they haven't filed on it. But if they do, they got the video. Good luck.
Are you doing no action on both?
Well, yeah. So if you want to jack him up, file it.
Your Honor, in regards to his original case, they would ask for no return and no contact with the victims and witnesses.
All right. I should have told him while he's here, since they say that he comes back all the time, and he always takes cases of beers. Like, all the time, it's a regular. Okay, Mr. Budrum?
Yes, ma'am.
All right, sir. Nice to see you again. All right. So, sir, this is an add-on charge in addition to the ones that we told you about the other day. And it was, well, I guess you knew you got arrested when you went to the probation office, but they supposedly, when they arrest you, they inventoried the car before towing, and they found some more stuff allegedly, so they're asking for $15,000 bond on the cannabis to intent to sell and $1,000 on the 28 grams of cannabis count two. If you didn't have all the other stuff going on, I'd be willing to talk to the lawyers and let them argue about lowering the bond, but you got everything else in there, and you got the VOP, so I want to just skip the messing with the bond, let you take it all downtown and deal with it as a package, all right?
Okay.
So if that judge wants to let you out, fine, but right now, I'll just leave the bonds where they are and
Thank you.
let them deal with it downtown.
Okay.
Your Honor, so that was 15,000 on one and 1,000 on two?
Correct.
Not received any paperwork about the new charges though.
The
Like,
new,
correct.
okay, well, I don't know what they give you in the jail as far as that, but, I mean, I can tell you what they did was they searched, I think it was a Mercedes or something, and they supposedly found a whole lot of pot. that was an interesting thing, allegedly, to be carrying with you for your probation appointment, but there you go.
Okay. Thank you.
Good luck. All right, Mr. Cannon? Yes. Sir, this is case number 2021 CF 577880. It's going to Division 11. Judge Laurent. We can appoint the public defender to represent you. Sir, they had enough information to at least file the charge of grand theft auto, and the bond is 1,000 on that. And I'm tempted to just at least leave it there and let you talk to your lawyer, and if you bond out, make sure you come back to your court date.
Your Honor, state would ask for no contact with the victims or witnesses.
No contact with victim or witnesses, if you know who they are.
One.
Oh, 1,000, sorry.
Or if you don't know who they are. Okay.
I don't know why it's.
Good afternoon, Your Honor.
Good afternoon, Mr. Castillo Conde.
Yes, ma'am.
Okay. You've got a couple things. You've got a new case called 2002-1 CF 552980 in Division 20 with Judge Wooten. It's alleged robbery by sudden snatching, which was the subject of an arrest warrant that was signed by a judge when the police made a sworn statement, an affidavit, and alleged that they had this evidence that you had taken a cell phone from somebody you knew, or they knew you, and with sort of a threat to hurt them if they didn't give you the phone. And so the bond set by that judge was $1,000 on the robbery by sudden snatching and $250 on the petty theft. And that violated your pretrial release on case number 2020 CF 4160, which was a burglary structure and a burglary of a conveyance, or otherwise known as vehicle. That's in Division 16 with Judge Barber. You already have a public defender on it. Now, I don't really want to touch Judge Barber's bond because she probably knew what she wanted when she wrote it. So talk to your public defender about that.
Your Honor, I'd also ask for no contact with victims or witnesses on the.
Sudden snatching?
Yes, Your Honor.
So ordered.
And no weapons.
No weapons. Okay, so ordered.
So I have to beat that.
Okay, we got a lot of customers today, sir. We need to move on. Thank you. Is this Mr. Bobby Crap?
You bonded, Your Honor.
Okay, thank you.
Michael Faison.
Is this Mr. Faisal? No?
He's in the hospital.
Oh, okay. Thank you. So he's got several other cases for which he's appointed the public defender counsel.
Yes, Your Honor.
I'm tempted to revoke him on those. Do you want to reset the case, or do you want to waive his appearance and talk to him about it later?
Your Honor, we can reset from 24 hours from release to the hospital.
For when he's released from the hospital?
Is he medical or hospital?
He's hospital.
Yeah.
Oh, so it could come any day and we don't know when?
Yes.
Okay, well, all right. No problem. Okay, is this Mr. Fleetwood?
Fleetwood refused court.
All right, Mr. Fleetwood is case number 2021 CF 5839AO, Division 14. We can appoint a public defender. Do you want to have him reset, or do you want me to deal with it now?
No, Your Honor, I'll waive the appearance.
All right, then. This was an alleged carjacking. They did have probable cause. And the bond requested is $20,000, which is appropriate.
Your Honor, state would request no contact with victims or witnesses, no return to the scene, no weapons, firearms, or ammunition.
So ordered. There might be another one pending, because it looked like there was supposedly two.
Two. Yes, Your Honor, I'm anticipating that potentially the other one will be tacked on.
Right,
And you stayed the bond at 20?
yeah,
Thank you.
you're welcome. Is this Mr. Ford?
Yes.
Okay, sir. Sir, we have a failure to appear warrant on case number 2020 CF 9204AO in Division 19 with Judge Roche. You already have the public defender, and it's alleged that you failed to appear a while back. I think, well, okay, maybe just the 3rd of May. And Judge Roche set it at no bond, but I'm assuming that your lawyers can get you back down there to talk to the judge about it? Okay,
Hey, I was supposed to be getting some mail from the public defender officer. I just got one the other day, but, I didn't know nothing about it. They came and arrested me the next day.
all right. I understand that can happen, but I'm not going to have enough information to know what the public defender showed you or sent you and when and how and, whether they got the right address. So what I'm hoping, and I need to depend upon, is that they'll pick up on this and, tell the judge right away,
Yes, ma'am.
especially if it was their fault and not yours.
It was.
And so usually, it could go either way once the paperwork. And you always have to make sure that you update your address with a public defender. If you have internet access, you can always look it up in the clerk's website. And if you don't have internet access, ask one of your kids or grandkids.
My kids in Georgia. That's where I'll be at mostly, in Georgia.
All right, well, but all you need is a internet.
Yes, ma'am.
I mean, and they got internet in Georgia.
Oh, yeah, I'm just.
So you can look it up.
Information.
It takes like 1 minute to
Right.
look up your case, okay? So you might want to start working on that. And if you're not used to it, then get one of your kids to do it, okay?
Yes, ma'am.
Because it's better than this. It's better than ending up in jail because you don't know what your court date is.
Yes, ma'am. I agree with you on that, ma'am.
All right. Good luck to you, sir.
Yes, ma'am. You have a blessed day.
You too. Oh, okay. Is this Miss Fuentes?
Yes, ma'am.
All right, ma'am, this is case number 2019 CF 4724AO. You do have a public defender, and Judge Calderon or whoever was there at the time in 2019 in Division 12 signed a warrant for a failure to appear to court on October 17, 2019. And it's sitting at no bond, and I generally don't like to change those because unless the judge gives me a clue on the paperwork, they generally don't want me to touch those failure to appear bonds. So I'm going to leave it at 0, but you got the public defender, and I'm hoping and trusting that they'll get you down there to talk to the judge about it sooner than later. Okay. Is this Mr. Gray?
Yes, ma'am.
All right, sir. Let's see, we have, you're a young fella, and it's one of those bicycle without a light stops, but allegedly, in regard to case number 2021 CF 5779, they supposedly found some, count one, possession of methamphetamine with a bond amount of 1,500 and fraudulent ID, count two, with a bond amount of 100. Division 19, we're going to appoint the public defender on that. Plus, you got a couple possession charges that you're out on bond for.
And Your Honor, I would ask that you not revoke the out on bond charges. It seems that it's more of a drug use issue than a like selling or anything. Even the new charge he picked up was a rolled cigar. So I'd ask that you take that into consideration. My client looks like is employed full-time, holding him at no bond. He has the potential of losing that job. So I ask that you take all of that into consideration.
I'm not really on a no bond status with this, but I just
Okay.
probably should do something, but
Yes, Your Honor. State would ask that you revoke and just double those bonds as he was out on drug-related charges and picked up new drug-related charges.
all right.
Condition is not to pick up any new charges.
All right, Mr. Gray, I think that the felony judge would not be too aggravated with me if I double the other bonds, but I have to do something because, you know, yeah, that's just what I had to do.
Yes, ma'am.
All right, and I wish you good luck on your drug issues, sir, because it'll hit you and mess you up and get you to get all these fines, and you'll never be able to vote, you'll never be able to get a license because you won't be able to pay the fines, and you won't be able to get a job with the felony convictions. Good luck with that.
All right, thank you. I'm working on it.
Your
You're
Honor, so before he leaves, for 21 CF 2852, the bond that he was originally out on was 1,000. So you're revoking
They're
and setting
both,
it
they're
at
both
2,000?
1,000, I'll revoke and put 2,000 on each one of them.
The bond on the 20 CF 9940 was 2,500.
No, last
No?
time he bonded, it was 1,000. Both of them were 1,000.
They're both being 2,000.
Yeah.
And you're staying the bonds on the new law.
Right.
Okay.
So if he's got, I guess he's gonna have to call his family member again. There does come a point where they stop bonding you out.
Yes, ma'am. This last time was actually my first time ever bonding out. So they're going to give me one more chance, and this is the last chance that I need, and I'll be okay.
Well, I hope so, because they'll eat your brain anyway.
Yes, ma'am. All right, thank you.
You're welcome. It's true. It'll eat your teeth, too. Have you seen those people on meth? Holy cow. By the time they're my age, well, they die long before that. All right, Mr. Griffin?
Yes, ma'am.
All right. Sir, we got an add-on for you today. It's called 2021 CF 5822AO. And they found a grand theft from May 13th. Allegedly, you went shopping, big time. I'm joking. We'll appoint a public defender. He's looking at me like he really doesn't. It's going to Division 12, Council. You know, I think I was looking at this and I didn't understand why they put it in for no bond. Am I missing something? Do you want to talk to your lawyer instead of me, because you might accidentally convict yourself? What I mean was, by going shopping, was it was a whole lot of allegedly stuff that you took. It's listed on the paperwork as an add-on, but,
It's not, Your Honor. It's its own separate incident, I believe. I know he has a lot of other open grand thefts.
Okay.
So I think that's where the confusion was, but it's its own.
All right, did he
independent
get
incident.
arrested on the 13th, and has he been in jail, or did he?
Yes, he's been in here
No
since.
bond?
The officer on the affidavit put it at a no bond.
No, I mean, on the other charges, is he being held at no bond?
Yes, he has some revoked charges that are at no bond.
Okay.
Your Honor, for this,
Maybe he got a violation of PTR or something in, I don't know, okay. So, but has he been in since the 13th on this?
On this case?
Yeah.
No, not on this case that we're seeing today, but he's been in here.
Okay, they found it, they just found another one. Okay, so, you know what happens, sir, is sometimes they're looking at the video and stuff.
No, he's stating that he doesn't know why his bond is at none.
Oh, we don't know either, we're talking about it. We're just talking about that, we're trying to figure it out. Okay, do you know why the officer did that?
no, Your Honor, I'm sure it was just a clerical error. He's entitled to
Right.
bond. So state
Okay,
would ask for a
well,
reasonable
all right.
bond. I would just point your attention to, he was recently released from DOC March 1st of charges of robbery and 3 counts of grand theft. 4
Okay,
counts.
and he's already amassed a bunch of things
Yes, Your Honor.
since then?
I just bring that to your attention when setting bond.
So what do you well, he's in there anyway, what do you recommend?
If 5,000 or below, Your Honor.
All right, well, it probably doesn't matter, because he's in there on some other stuff, counsel.
Yes, Your Honor, he's disputing that he should be held at no bond. I don't have any.
We're not gonna hold you at no bond, we're just figuring out what the number is, because
No.
the state's arguing that you just got out of prison and now you've got a bunch of other stuff.
I got out of prison, came back here for the grand theft, and I found out in 2019 they had a charges for me. That's what I'm saying. These were the charges from 2019. I've been in prison ever since. Before then.
You got more than that.
Yeah, and they revoked my bonds for the ones in 19. I don't know why.
Well, I don't know, unless somebody's making a mistake, you got some other stuff. You know, sir, actually, I can't unravel this for you right now. I cannot resolve the mystery. I'm tempted to think that they got you on video for some stuff that you don't know that they got you on, but I'm not sure if that's exactly true. Let me go with 2,500 because he's in there anyway. I'm not really worried about him getting out. And we'll appoint the public defender.
State would ask for no return and no contact with victims or witnesses.
No return and no contact.
You say 2,500, Your Honor?
Yeah,
And
A new chart.
he's in there anyway. Okay. Next one is 21 CF 5619AO. All right, is this Mr. Horton?
Yes, ma'am.
Okay. Sir, I think you got picked up on a warrant, and we're going to appoint the public defender to represent you.
Yes, ma'am.
The case,
it was a warrant, Your Honor, but we have since filed an information.
okay. Is there different charges, or
No,
should we
Your
just
Honor.
run
It
through?
exactly tracks what the
Okay,
warrant
thank
was.
you. All right, so, sir, the judge who signed the warrant set some bond amounts, which are,
Your Honor.
you have the right to remain silent. Would you like to talk to the lawyer I just appointed?
Yes, ma'am.
Okay. It's 19.
Your Honor, I would just ask that since he does qualify for, pretrial release?
No, it was.
It is not.
He doesn't.
Oh, he doesn't? Okay. Well, I don't know.
Yeah, he's got history, so that was one of those
Yeah.
typos.
Yeah, Your Honor, he, would like the court to know that he's only employed part-time. So, at this time, him and his, wife are currently homeless, and they would just, he wants to just ask if you would consider lowering, the $2,500 bond down a little so that he is able to bond out.
Your Honor, according to the facts that are in the affidavit and the PC, affidavit from when this was direct infoed, it is a pretty significant facts that are alleged in this. With the defendant screaming that he was going to kill her by slitting her throat, locking herself in the bathroom, grabbing a knife, hitting her. There's pretty serious facts alleged in that affidavit. I believe the bond is appropriate, if not a little low, so I'd ask that you leave it stayed.
All right. I hear what everybody's saying, Mr. Horton. I know you're only 19, but the bonds are relatively proportional to the allegations, so I'm going to go ahead and stay the bonds. You've got $2,500 on the aggravated assault charge with a deadly weapon, count 1.
Your Honor.
$1,000 on count 2, aggravated assault with a deadly weapon. $100 on count 3, battery. $100 on count 4, battery, and $100 on count 3, criminal mischief. Also, the requirements are no contact directly or indirectly with the victim or witness. Maintain separate residence, don't return to the scene, don't possess, consume any alcohol, illegal drugs, or controlled substances without a valid prescription. If you have any guns, weapons, or firearms, put those in the custody of the arresting agency within 24 hours of your release. The next one is 21 CF 5821. Mr. Hyacinth.
I seen refuse court, Your Honor.
Okay. Let's appoint the public defender in regard to that.
I'll waive the appearance, Your Honor.
Okay, thank you. And it's going to Division 16, Counsel. Let's find probable cause for aggravated assault with a deadly weapon at $2,500 and resisting an officer without violence at $100. No contact with alleged victim, separate residence, police escort if needed to get things out of the residence. Put any guns, knives, or weapons in the custody of the arresting authority within 24 hours of release. All right. Okay, how about Mr. Mahone?
Yes, ma'am.
Thank you, sir. This is case number 2020 CF 15255. And we can appoint the public defender, sir, if they were not previously appointed. Evidently, you were arrested on a warrant. It's going to Division 20, Counsel. In regard to an alleged burglary of a dwelling, that was alleged to have occurred on December 26th, reported, I think, by the mother of some children that you have in common. So is this a domestic, actually? And the judge who signed the warrant put the bond at $5,000 on the burglary of occupied dwelling, no bond on aggravated stalking after an injunction, and $500 on the criminal mischief. So we're supposed to review that at this time. just picked up on it. That's the only one he's got right now, right? And there's some criminal history. Whatever and they filed, three charges?
Yes, Your Honor. We filed the burg dwelling F2, a violation of an injustice injunction, an M1, and a criminal mischief M1.
Okay. Exactly, okay. All right, so, sir, I don't know what has happened in between those times, but you are required always to have no contact with the alleged victim while the case is pending. I don't know what's going on in juvenile court or with Department of Children or Family Services. You need to follow any orders from either the juvenile court or Department of Children and Family Services. If there are no orders, then you need a third party to help you either exchange or carry out visitation with the child or children. No guns, weapons of any kind. Those are to be surrendered to the law enforcement agency that arrested you within 24 hours, if any release.
Your Honor, state would also ask for a no return to the victim's residence as well.
No return. Was there an indication that they were living together at the time?
No, Your Honor, they're not.
Okay, don't return.
And state would also ask that you set it as a condition for him to comply with the injunction in 19 DR 11081.
Right, comply with the injunction, any injunction.
Your Honor, in regards to bond.
Yeah.
I would just ask that you stay count 1 and count 3 as previously set on the warrant by the previous judge. In regards to count 2, the allegations in the affidavit are pretty troubling. One incident is him kicking in her front door at 4 a.m. and stepping into the residence when her children were present, and possibly damaging other of her personal property. There's also another alleged incident where he broke in through a window and was armed with a firearm. There is an active injunction in place, and I don't know if any bond conditions that would definitely secure the victim's safety as well as the public safety. So for count 2, state's asking for a bond of $5,000.
5 and 5, okay. Well, does the state have any indication that anything has happened since December? Because that's relevant to the concerns of immediate safety.
Your Honor, I'm not sure. I mean, I would just argue that there was an injunction in place, and in regards to the victim's safety and in regards to the integrity of the court, he did violate an injunction. And ask that you set bond that it's appropriate for that.
All right, and he also has some history, counsel. I'm tempted to take into consideration that if there was any other contact between December and now, we would have information about that.
Yes, sir.
And so evidently things have calmed down at the moment. I want to warn Mr. Mahoney that if you're just finding out about the fact that she called the police on this, don't, let your anger about that cause you to have contact with her or to try to tell her not to testify, because it's real close to a no bond situation. I've heard prosecutors argue up and down, inside out, and just, until we almost wanted to die and go home over these, where you're kicking in the door type of things. Like, it's extremely serious, to be honest. So the only reason I'm going along with $5,000 on the burglar with an occupied dwelling is because there's been time passed and evidently nothing maybe happened since then. So on the aggravated stalking after injunction, I'll put that at 500 and leave the criminal mischief at 500. So I've set bond on the no bond and not hiked him up too bad and appointed the public defender. As the prosecutor suggested, the no contact, don't return. And as I already told you, if you need to talk with, well, the original judge said no contact with the victim's children either. But I've already told you that if there are any requirements by DCF or the juvenile court, follow those. And if none, it has to be through a third party at the very least. And I'm reluctant even to do that because of your background and history. Good luck. Did we do Mr. Maldonado Torres already?
No, Your Honor, that is they move up for Spanish interpreter.
Oh.
I think it's a one.
You want me to do him next?
Yeah.
Well,
You do her.
okay, so this is Miss Odom, right?
Yes.
Okay,
ma'am.
thank you. Sorry if I confused you.
That's okay, ma'am.
I have a lot of cases here.
You had a long day today.
I do, actually. Thank you. All right, thank you. Ma'am, we have case number 2021 CF 5741, and I believe this was a warrant alleging a home invasion robbery count 1 and a grand theft third degree count 2, allegedly from May 15th, and it was signed by Judge Jordan. The home invasion robbery with a deadly weapon could be punishable by life imprisonment.
It is, Your Honor. State will be asking that you hold a no bond pending an Arthur hearing. It's a life offense.
Okay. I didn't read the affidavit yet. Looks like some primarily controlled substance and some batteries, criminal mischief, aggravated assault with deadly weapon, aggravated battery with a deadly weapon, arrests, even including juveniles. So it's not without any criminal violent history. Did I specify that we were appointing the public defender yet?
Not yet, Your Honor.
Okay, let's do that. And she's gonna argue for me to set a bond, I think, but,
Yes, Your Honor. I would argue that you set a bond in this case.
all right, let's look at it real quick. I didn't get this far. Well, ma'am, based on the allegations, I'm gonna leave it the way it is right now and let you take it downtown with your lawyer. I guess, were you out on bond? It looks like she was out on bond.
Your Honor, so for the record, for the home invasion robbery, you're setting it at no bond, and are you saying the grand theft at 500?
Yes, ma'am.
State would request no contact with victims or witnesses while she's in custody.
So ordered. Ma'am, on the possession of methamphetamine, that you're out on $1,500 bond. Since you're in there anyway, I think that judge expects me to revoke this, but your public defenders will put them together and deal with them together.
Your Honor, it was revoked and set at 0.
Yep. Is this Mr. Red? Oh, this is Mr. Maldonado? Okay. is an interpreter case, right?
Yeah.
This is Maldonado Torres.
Okay. This is case number 2021 CF 5841. Mr. Maldonado Torres.
Good afternoon, Your Honor. This is Salo Figueroa, assistant transport interpreter.
Thank you. Did you catch it when I was saying the case number?
I did not, Your Honor. I think I hadn't connected yet. If you could please repeat it for me.
Yeah, 2021 CF 584180. Mr. Juan Luis Maldonado Torres.
Thank you, Your Honor.
Thank you.
See.
The defendant can hear me, Your Honor.
Thank you. Sir, we can appoint the public defender to represent you. This case is going to Division 20, Counsel. The allegation is a tampering with physical evidence charge. And that might be trying to throw a pipe away. And they probably have enough information to file it. And I guess they're filing it as originally as a felony. It might end up being a misdemeanor later, but doesn't have much history that we know of. He might have some mental health problems. I think he's on SSI. And I don't know that he was qualified for, well, I don't know if you do pre-trial release on these or not, but he just doesn't have that much of a history that we know of. I'm tempted to set it at 500 unless he qualifies for some pre-trial release.
Respectfully, this is a felony. I think 500 is not in keeping with the level charge that it is at.
Your Honor, my client has zero criminal history, and it was a glass pipe. So I ask that you take all of that into consideration. His history, the fact that he's on Social Security, disability, and set the bond at 500.
Your Honor, he doesn't qualify for pretrial release. He gave us no address as he's transient, no telephone number, no emergency contact, no information. Just
All right, I think it's the situation. He's probably homeless. But I'll lower the bond a little bit, sir. And if you can call anybody, maybe that'll make it a little easier for you because of your lack of criminal history. I think that's appropriate.
Your Honor, state would ask that it be a condition of no drugs or alcohol without a valid prescription.
Okay.
$500.
Thank you. And that's all we needed. Thank you very much, sir.
Not a problem, Your Honor.
Thanks. Okay. Is this Mr. Red?
Yes, ma'am.
Okay, sir. All right, we have a case, 2021 CF 2026. And that you've been out on bond for, I guess. Since February, and then we have 2021 CF 5788, which we can appoint the public defender on. It's Division 19. It was a warrant signed by Judge Jordan in relation to an allegation of possession of firearm by a convicted delinquent, and that judge set the bond at $4,000, and also required a condition: do not possess any weapons, firearms, or ammunition. It appears that this alleged occurrence might have predated or was the same date that you got the other charges. And hopefully this is not an add-on, maybe it's just an add-on and not. So the other ones were fleeing, attempted to elude, no driver's license. This is probably an add-on, isn't it?
1 second, Your Honor.
Yeah?
1 second.
Okay, thanks. Yeah, it is. It's an add-on.
I ask that you take no action, Your Honor, on the out on bond.
Well, no, I'm not going to tell you it's the same case.
Thank you.
As a matter of fact, is this all you got arrested on?
Yes, Your Honor.
Oh, okay. So what happens is that the judge who got the warrant probably may or may not have had immediate access to the other file to realize it's probably from the same incident, unless there was something else you took into consideration. Let's look at your background history. All right, you got some, but it looks like it's really an add-on. I'm not going to do anything to the case number 2021 CF 5788 unless the state has something new to tell me, but I think what happens is, so they, sometimes they file another charge out of it, the same incident, and I think that's what it was. So I'm going to change the bond because I don't know that Judge Jordan, he may have had a whole stack of things he was looking at and didn't have that other case, so I'm going to call it 150 and appoint PD. And what you want for them to do is to consolidate it with the other case.
Yes, ma'am.
All right, but make sure you get all your case number or your court dates straight, because the old one is Division 15. The new one's going to Division 19 until somebody files a motion, literally.
Your Honor.
It's an order signed. Did I miss something?
No, regarding the bond, I'd bring attention to his criminal history. He has several Burr conveyances with VOPs, several carjackings with a firearm, robbery with a firearm, grand theft motor vehicles with violations. He has a very significant firearm history as well as violent history. I believe the $4,000 bond on that charge is appropriate given his history and his such a young age with the history that he has.
Yeah, well, I wonder if the judge who made the original determination of 5,100 on the fleeing attempted to elude no valid license took that into consideration, because it would have been the same police report.
Your Honor, I'm not sure what that judge took into account. I know for Judge Gibson, when she has a fleeing attempting to elude, she usually puts it at $15,000. When Judge Bain generally has a fleeing attempting to elude, he usually puts it at $2,500. So there's a lot of movement on fleeing and attempting to elude.
Well, yeah, different judges with different levels of exposure. Of course, they were both prosecutors, so, it's not like they'd never seen them. And then, I understand what you're saying, and I wouldn't take it, I don't take it lightly that he's traveling around with a gun, not at all. I mean, usually when I first look at the gun charges, I just put it at 5,000 because I figure, it's a health safety consideration, and people his age, sorry, but, I had to represent people your age, and, guns go off, and then you're representing a kid on a murder charge. So, yeah, it's extremely serious. But as I said already 2 or 3 times, I just think it's an add-on, and that's the way I'm going to treat it, even though, it's serious. It is serious.
Thank you, Your Honor.
All right.
So you said 150, correct?
Yes, ma'am.
Thank you.
Thank you for remembering all that in the middle of what was going on. Is this Mr. Rodriguez?
Rodriguez
ma'am.
bonded.
Oh, I heard 3 times, thanks.
He bonded.
Rodriguez?
Okay. Is it Mr., well, who's that?
He didn't know somebody bonded him out.
Oh, he didn't know they bonded him out. That's why he answered yes. Okay. Is this Mr. Roll? Okay, thank you, sir. Sir, this is case number 21 CF 5739. Going to Division 22. And I think we're going to appoint the public defender. They've already filed a notice of invocation of constitutional rights that they don't want anybody trying to talk to you, and that you don't need to say anything to anybody about it. It's a warrant for an alleged home invasion, robbery with a weapon, count 1 at no bond, and grand theft, 3rd degree, at a $500 bond. It was alleged to have occurred on May 15th. And that being a first-degree felony punishable by life imprisonment oftentimes is at just no bond. And like I said, the judge found probable cause.
State would ask that you hold him no bond pending an Arthur hearing. This is the co-defendant to Miss West, who we saw earlier.
I'm
To
sorry, I
Miss-
didn't hear everything you said. No contact with her or what?
It was a co-defendant case, the one you
Miss
held at
Odom.
no bond, Your Honor, earlier.
Right. Well, I put him at no bond. Or I was going to put him at no bond. All right, sir. Was this the one at the Walgreens or the one at the,
No, Your Honor, this is the hotel with Miss Odom.
oh, okay. All right, so it's at no bond, sir, which is pretty standard, but you have the public defender. It looks like you might have been out on bond in regard to case number 2021CF1060AO. And I think you already have the public defender on that. It was a possession of, or trafficking in methamphetamine, deliver cocaine, destruction of evidence, possession of cocaine, Division 16, with Attorney Flieger. Probably the judge on that case is going to expect I revoked a bond and just hold you at no bond, and what you want to do, try to get both judges to put them together in one division and look at them as a package.
Your Honor, are you staying the bond on count 2 at 500?
On the
Grand theft?
yeah,
State will request a no return, no contact with victims or witnesses or co-defendants, Ms. Odom, and no weapons or firearms.
so ordered, thank you. Mr. Salaberry?
Yes, ma'am.
Okay. This case number 2021 CF 5843AO. And if that's your income every 2 weeks, you might be just over the amount for the public defender. But if you get out and you can't get the public defender, or if, not sure if they're asking me to appoint, are you asking me to appoint anyway when they don't qualify?
Yes, Your Honor. At least at IA until they can get a private attorney.
Okay, so, it might be a temporary appointment at the public defender, but, you technically don't qualify. All right, although if you can't get out of jail, that, might be a circumstance that might change. So the allegation is possession of cocaine with intent to sell, count 1, and possession of heroin, count 2.
Your Honor, he does qualify for pretrial release. So I would just ask that he be placed on pretrial release. Majority of his convictions are nonviolent offenses.
Your Honor, his risk assessment is high, and he does have multiple probation violations. So I'm worried about his compliance with PTR, given that he violates probation when placed on probation. And PTR is arguably kind of like probation in that he has to report. So I'm concerned about his compliance with PTR. So if you're inclined to put him on PTR, I'd ask for a monetary bond in conjunction with PTR.
So the circumstances now are that these drug charges are going to add up to PTR? Because he's got some priors, so I'm just not used to PTR with priors like this. And we had a couple of typos on the PTR before, so I'm sort of asking her to tell us if it's a real qualification or not.
As from what the person who interviewed Mr. Soliberry, due to his compliance, I guess he did qualify him.
I'm having a hard.
For the person who interviewed Mr. Soliberry, during the interview, he did cooperate, gave information, so that's why he qualified him, and the charges do qualify.
Really?
But it's up to you, Your Honor.
Okay. Well, that's interesting.
If he doesn't comply, Your Honor, with pretrial release, he'll be brought back here for a violation of the pretrial release conditions. So I just ask that you place him on pretrial release.
Okay, so I actually need to, I didn't get this far down in the stack. I just want to see in that the clerk's office thinks that the bond was supposed to be doubled, I think, or corrections, put, on the one hand, they're saying pretrial release, and then on the other hand, I've got a bail bond correction form in the amount of $15,000 because I'm not sure if they've doubled the bond now for possession of cocaine with intent to sell from $75,000 to $15,000, but
No, Your Honor, the bond schedule for possession of cocaine with intent to sell or deliver is $15,000, as is an F2.
okay, so
That's
that's
the
just,
standard bond. I believe it came in incorrectly at the 7,500.
all right. We might have been doing 7,500 years ago when I was here, so that, I had to ask about that. Let me see.
15,000 is the correct amount, Your Honor.
Okay, so he's got numerous small amounts of different things.
Yes, Your Honor, along with numerous small yellow plastic bags, medium plastic bags, white plastic bags, a scale, and a razor blade to cut up crack cocaine.
Right, and $100, so he's sort of small time, but he's got a lot of things. And so on the one hand, he's qualified for 3 pretrial release, which I'm really not familiar with from the past. And he's got 4 failures to appear. Sorry. Sir, I'm tempted to leave it at where they started instead of the doubling and instead of the PTR, just because you got some history and you got multiple things. It looks like you're trying to, have a business, but you need to stop. You're going to wreck your life that way. I'm just going to leave it at 7,500 on count 1, possession of cocaine with intent to sell, and 150 on possession of heroin. And I hope you make better decisions in the
Your Honor,
future.
Thank you, Your Honor. No drugs or alcohol without a valid prescription.
No drugs or alcohol without a valid prescription.
And no weapons.
And no weapons. Okay. Okay. Mr. Sanchez Volbrecht, I think we saw you maybe yesterday or the day before. Let's go ahead and appoint a public defender. And what I think we have is a bunch of add-on charges. And so I wasn't going to worry too much about the bonds because when there's that many, I just want to give you the lawyer and tell him to take it all downtown so that everything can be put together eventually and looked at as sort of a package. And I can't remember what we saw you for yesterday or the day before, but case number 2021 CF 5815 is going to Division 17. The other thing is they'll probably all go to the division where the case number is the lowest, but right at the moment, they're going to different places. But this one is an alleged driving while license suspended, and they're asking for a $2,500 bond with supposedly a fair number of suspensions, but it's really just academic at the moment. We just have to go through the cases, batch them up, and send them downtown, okay? So I'll leave it at that. The next one is 2021 CF 5816, going to Division 11. And that's an alleged burglary of an unoccupied structure and grand theft. And that one was allegedly on the 18th of May, and something about, it looks like taking some lumber.
Your Honor, I believe 5816 was a theft from J.A. Crossan's Connex container, which was a saw and a vacuum, another saw, a hammer, extension cords, and locks.
Okay. With a bond of $1,000 on count one for the burglary and $150 on the grand theft and finding a probable cause on that.
Your Honor, state would ask for no return and no contact.
No return, no contact with the witnesses or victim.
I'm sorry, how much on the burglary charge, Your Honor?
1,000.
Okay.
Right. 2021 CF 5814, Division 20, public defender appointed. This one is called a burglary of structure and trespass on designated construction site. Okay, so this was the construction site. And taking some materials and tools, et cetera, on May 16th. And it looks like they do have information enough to file the charges on both of them. And so the bond, I'll leave the bond at $3,500 on count one, burglary of structure, $150 on trespass on construction site.
Again, state would ask for no return and no contact. Your
No
Honor.
return and no contact with the alleged victim or witnesses. Okay, 21 CF 5817, Division 19, appointing the public defender, another burglary, criminal mischief, petty theft case. This one was Bay Area Building Services, allegedly damage to the door and taking a drill. So it appears they have enough information to file that one. The bond on the burglary to an unoccupied structure is 1,000, count one, 150, count two, criminal mischief, 100 on the petty theft. No return, no contact with victims or witnesses. It's alleged that you have a very intense work ethic, Mr. Sanchez Volbrecht. Case number 2021 CF 5818, going to Division 20, another burglary. On the 17th of May, allegedly, at Delta Fire Sprinklers or a trailer. I guess there's some admissions in regard to that one. So we'll find probable cause, set bond at 1,000 on count 1 burglary of unoccupied structure and 100 on the criminal mischief. Now we're into the misdemeanors.
Your Honor, you're also doing a no return, no contact on that one?
No return, no contact with the alleged victims or witnesses. Okay, case number 2002-1MM3371AO, Division 61, alleged petty theft with a bond amount of 500 in regard to the 16th of May. In regards to some 2x6s by 10s at a job site on behalf of Barber and Associates. And it appears they have probable cause for that, so that's a $500 bond on the petty theft. Okay, no. 2002-1 CF 5819, Division 14, grand theft motor vehicle. May 10th, in regard to a trailer owned by Kevin Guerra. And they've got some video on that. There's enough information to file the charge with the bond amount 1,000. 2002-1 CF 5820, Division 10, grand theft motor vehicle. Appointing the public defender, and it's a $1,000 bond, and another video of another trailer, and hopefully that's all of them, sir.
And Your Honor, just for ease for the clerks, they request no return, no contact with victims and witnesses on all, as well as no weapons or firearms.
That'll be fine. I'm happy to sign that. Thank you.
Your Honor, Ms. Sears refused court. See it.
Okay, guess we can appoint the public defender.
I'll waive the appearance, Your Honor.
All right, she has a few, though. Let's see, she's got 2002-1 CF 5831, Division 17, appoint the public defender. So the burglary, was that for the car, going into the car? Oh, no, that's Walgreens. Oh, okay. There's enough information to file the charge of burglar of occupied structure, I guess. She's just got so many, they'll just have to be weeded out at $5,000 for going behind the counter, I guess. And petty theft, retail at 100. We'll stay those and tell her not to return, no contact with alleged victims or witnesses. Case number 2002-1 CF 5830, that one's going to Division 11. We'll appoint the public defender, and that was the alleged carjacking at the Walgreens, I think. Yeah, the Walgreens. And there is probable cause, and $20,000 bond is appropriate probably on that. What's, wait a minute. Right, so another one, 2002-1 CF 5829 is going to Division 22. We'll appoint the public defender. Okay, this is the one with the Wendy's. And the other co-defendant, we didn't get that one, that charge on him today. Okay, so he supposedly threatened to shoot the victim in the case at the Wendy's. And Anna was entering into the vehicle, so, and she kept screaming, "Get out or we will shoot." So, okay. We'll find PC for carjacking with a firearm, and counsel, I know you'll all take these downtown and sort out what
Yes.
ultimately will be done with them. And then,
Are you staying the bond on that one, Your Honor?
yeah, I'll stay at no bond. I mean, the whole situation was way out of control, so I don't have any problem letting the judges downtown decide what to do with these two.
Yes, Your Honor.
All right, 2021 CF 5828, Division 10, appointing the public defender. Evidently, while she was driving, she supposedly had an HTO. And so we'll find probable cause and leave the bond at the 2,500 on that. Here, and this is. That was a lot of paperwork.
Your Honor, I believe she has a few more.
She has more?
I believe so.
He has one more.
5832 of fleeing and attempting to elude.
Oh, okay, you know, I probably missed that in all the stack here. Let me find it. Oh, okay. I found it. Oh, that's right. After the Wendy's carjacking.
He fled in the vehicle.
Okay. All right, well, let's, counsel, let's find probable cause, leave it at no bond, and defense, like I said, they'll sort it out down the line.
For the fleeing and looting?
Your Honor,
I believe
she's
she's
entitled
entitled
to
to-
bond
She's
on a
entitled to
fleeing
the
and...
bond on the fleeing attempted to elude?
Yes, Your Honor, we cannot leave that one as no bond.
All right. What do you suggest?
Judge Gibson usually sets them at 15,000. Judge Bain usually sets them at 2,500.
Let's go with 5,000. It doesn't matter, but, you know, I guess I'm in the middle of the two. I just don't care because after I do no bond, it doesn't matter.
Yes, Your Honor. Just for the record, on all of them, state would ask for no contact with victim witnesses or the co-defendant in this case, Mr. Fleetwood.
Okay, so ordered, and I appreciate your continuing to remind me on that. All right, is this Mr. Sherman? Okay, sorry about that, Mr. Sherman. I just want to get that one out of the way. All right. Sir, this is case number 2002-1 CF 5800. We'll appoint the public defender, and this is one of those where and it's going to Division 11, counsel, alleged that you failed to register, and I think you know what I'm talking about. Looks like you have an address in Pennsylvania. Did you get brought down here for this?
No, ma'am.
Okay. Okay. Well, it looks like you went sort of incognito. They haven't been able to get in touch with you. And you had not registered in Florida. Okay. Is this one that comes in no bond and we set something?
Yes, Your Honor.
All right, and, you know, based upon the number of years that I've been off the bench, I can't remember what we usually do on these. Do you have any suggestions?
Your Honor, it is an F3, so he is entitled to bond. Given the affidavit, I would recommend 15,000. He told investigators, or investigators in Pennsylvania made a comment that he told his sex offender treatment group that he was stalking a 10 to 13-year-old female to be his next victim. And then he subsequently moved down here to Florida and moved into a hotel and did not keep up with his reporting requirements. So I believe it's appropriate, given the nature of the charge and the potential damage to the next victim, to say would ask for 15,000.
Your Honor, I would object. My client is currently on Social Security income. You might as well hold him at no bond if you set it at 15,000. Your Honor, so I just ask that you take that into consideration. He has looks like zero failures to appear on his record. So when setting the bond, I just ask that you consider all of those things.
He does, however, have 2 fugitive warrants, Your Honor, that he'll probably be seen on later.
Yeah, I think that Pennsylvania's going to want to bring him back, maybe 2 for failure to report.
But I don't know, Your Honor. I can't see the
Yeah, they're
fugitive warrant.
extraditing him.
Yeah. There's 2 warrants out of there. He's an Army veteran. All right, well, sir, no, obviously this is concerning. I don't always hit people hard just for failure to report, but, the concerns about the allegations and then leaving the state and everything, I'll put it at 5,000. Talk to the public defender, and then you're going to have to deal with Pennsylvania too.
Your Honor, usually a condition is to make it to report to the sheriff's office within 48 hours to report as a sexual offender.
All right.
And to maintain his reporting requirements.
All right. Okay, that's so ordered. Up 5,000. I can see how that'd be confusing when we talk about 3 different kinds. Is this Ms. Smith?
Yes.
All right, thank you, ma'am.
Welcome.
We have case number 2021 CF 5782. And we can appoint the public defender to represent you. The allegation is possession of methamphetamine.
Your Honor, she does qualify for pretrial release, so I would just ask for pretrial release.
Yeah, it looks like not much of much history, maybe an arrest and she's here allegedly on vacation and intends to go back to North Carolina. And my understanding is they don't keep you from going back, but you have to stay in touch with them if we let you out. All right, so, and it's Division 11. So, ma'am, we'll find probable cause for that possession charge. Let you get out with the, supervised program from pretrial release, and wish you good luck. That stuff is pretty bad.
Your Honor, state would ask for no drugs or alcohol without a valid prescription and random urinalysis.
All right, ma'am, do you understand that that would be a condition of your release, that you take no drugs, and they could randomly have you get tested?
Your Honor.
Yes, ma'am.
I'm sorry, what was that?
I heard, but are you allowing her to return to North Carolina?
Yeah, because you need a specific permission for that, right?
Yes.
Yeah, okay, so unless you see anything problematic, I would certainly let her go back to home. All right. Good luck.
Thank you. Have a good day.
You too. Okay, is this Ms. Stiles?
Yes, ma'am.
Oh, I'm sorry. I'm half blind. I'm really sorry about that.
It's okay.
I know you think I was saying that lightly, but I really am half blind. All right, it's case number 2021 CF 5783, Division 15. And the allegation is possession of cocaine and possession of cannabis. Looks like some priors, so you might not have pretrial release eligibility. You're on SSI. You might have some mental health issues.
Yes.
Okay. As well as being disabled. Let's see what we have, because
Your Honor, would you be inclined to lower the $1,000 bond amount, being that he is on Social Security disability, and it appears that in 2019 he's been deemed mentally incompetent to stand trial?
oh, really? Yeah, yeah. Stay, he doesn't seem, if, I don't think he's a threat to the community, to be honest with you.
I'm not.
Don't say anything about your case, and he's 29. And you have any family members or anything that can?
I don't have nothing. I'm homeless. I'm homeless. I've been homeless. Look at my hand.
Okay.
My
Your
hand.
Honor, I would ask for ROR. It doesn't seem that he has, looks like most of it is trespass and occupied structure, property. With him being mentally unable to stand trial, he's gonna sit here. We can't plea him out. So I would just ask that you ROR him, which is normally what happens in the long run anyway.
So, sir, how, do you know that if you're going to be able to get to court?
When?
Sir?
When?
Your Honor, he
When?
doesn't qualify for ROR, given that he does have 3 prior battery arrests and 2 prior failures to appear, one of which was extremely recent.
Your Honor, he does. It's in your discretion. If you are inclined to place him on it, it is still in your discretion if you would like to place him on ROR. This is in like normal circumstances, given the fact that he's on Social Security disability, he's homeless. I would just ask that you consider that.
All right. Well, if I let you out, you might get, have a hard time getting back to court, and
No, I won't.
then they'll, they'll revoke your bond and you would be sitting there anyway. If you were found incompetent to stand trial before, it could happen again. I don't know. It depends on,
I can go to court now. I don't have no problem with that.
well, you seem to be pretty clear right now. I'm going to release him. Now, sir, I'm just going to tell you this. I don't think you're a threat to the community,
Thank you, ma'am.
but, and I don't generally do this, but I just think you've got a pile of issues to deal with, and self-medicating is probably going to get you back in jail periodically, but
No.
make sure you go to court or they'll scrape you back up, and we'll give you the address and phone number of the public defender's office. If you want their help, you might want to talk to them before your court date.
Thank you, Judge.
You're welcome. So, corrections has that Destiny Wallace bonded. That was an assortment. Okay. Is this Mr. Archibald?
Yes, ma'am. Good evening.
Good evening, sir. Sir, this is case number 2021 MM 3375. And you might have had a case you were out on bond on, so we need to deal with that also. And did all this cause a felony VOP?
Yes, Your Honor. He was on probation for felony robbery.
Okay, thank you. First thing we need to do is appoint the public defender, sir, on everything. so in regard to the misdemeanor, they have enough information to file the charge of trespass after warning and resisting an officer without violence in case number 2002-1MM3375, Division 83, public defender appointed. The trespass is at 500 and the resisting is at 100 as a subsidiary.
They would ask for a no return.
No
and
return
contact.
and no contact with the alleged victims or witnesses. In regard to, okay, so there was a domestic battery outstanding that you bonded out on April in 2002, 1MM 131380. And the bond was 1,500 on that. Let's go ahead and up it a little bit. The real problem is your probation violation. So, yeah. Let's see how bad your history is. We don't have a lot on here. I don't think they had, okay, well, no, we do. Okay, all right, well, okay, well, let's, instead of no bonding you on the battery, let's revoke it and double it to 3,000, so at least you have something, but I'm not revoking it completely. The real problem is the probation violation. Those, that one is at 20 CF 9735. It'll come in at no bond. You'll see the judge pretty soon on that. You'll know what the bottom line is going to be, because it's a misdemeanor. But it's also a misdemeanor while you were out on a misdemeanor. And, you know, it could cause a problem, but you have a public defender for everything.
So what is for? What's this? What's this? So how much it is for 10%? I go to court for juvenile. I go to trial.
Good luck. Okay. All right, sir, Mr. Carpio Mello? All right, sir. This is a felony probation case, number 2018 CF 8441, Division 19. Technically, you don't qualify for the public defender, but we're going to go ahead and appoint them anyway because of the situation until you get to court. It's alleged that you violated probation on a sexual battery and lewd and lascivious case in relation to getting on the internet before you completed your treatment. Judge Roche set it at no bond for now. And that's just the way it is until you get back to the probation judge. Good luck. Mr. Cooksey? Okay. Looks like we have maybe a couple of violation of probation warrants. Here, let's see. Case number 2019 CF 11944 and 11943. One's in Division 10, one's in Division 12. 11944 was a resisting an officer with violence and battery upon person over 65. And the 11943 was a simple battery, but it was in felony court. There's an allegation of violation of probation on those, in which it was alleged that you violated probation by leaving your county of residence and going to Brevard County, failing to attend and successfully complete the drug and alcohol evaluation, and not showing up on the 9th of June at a specific program evaluation. And if there are more, sometimes what I used to have, and I guess that's it. I don't think there's a second page on that. So in regard to the felony one, the resisting with violence and battery on person over 65, it comes in at no bond. On the other one, the simple battery, the bond is at $2,500. Hopefully, you being supervised by the same state probation officer on those, and they can all be resolved at the same time. But basically what happens is you go over there pretty quickly. I think the clerk told me that it's about a week or so, maybe, that you get to see the VOP judge and see if you can, I don't know if you can resolve it, but maybe, they've got a bottom line recommendation at that time. Okay, is this Mr. Crossley?
Yes, ma'am.
Okay, thank you. These are case numbers 2018 CF 7684 and 2019 CF 13680, for which you would have been on probation for. 3680 was in Division 11, 7684 is in Division 20, and 7684 was a domestic battery by strangulation, and 13680 was grand theft motor vehicle, fleeing and attempting to elude, resisting without violence. Now, the allegation of violation of probation, and we'll appoint the public defender. Where is that? It's alleged that you got a all right, so you supposedly violated the domestic battery strangulation by getting the grand theft auto, fleeing and attempting to elude, resisting without violence, back allegedly on September 27th, 2019. And the, what we would call new charges, the grand theft, fleeing and attempting to elude, resisting, that's not a VOP, that's a failure to appear. And you got a no bond on the failure to appear and a no bond on the violation of probation. So we'll appoint the public defender and the judges, wait a minute. So you don't technically qualify before you got put back in jail, but we'll appoint the public defender anyway and let the downtown judge deal with it.
Thank you, Your Honor.
You're welcome. Mr. Ellington? Sir? Okay. We have case number 2021 CF 583380, for which you would have been on probation. You are qualified for the public defender's representation. And it's alleged, it's a Division 12 let me see, case. Is there more than one case number? Two cases. Okay, so it looks like you got a new case, 2021 CF 5833. Let's see. right, so the allegation is that you got a possession of Percocet and cannabis on the 18th of May. I need to look at it real quickly. All right, so, which ones did Ellington supposedly have? Okay. All right, well, the lawyers can argue later about whether or not you put the stuff on the floor of the car, sir. And that's going to be a legitimate issue that they'll have to deal with. Did we hike up the bond amount on possession of oxycodone to 2,500 instead of 1,000? Or did they just do that because he's on probation?
I believe it's because he was on probation, Your Honor. State would ask for 1,000.
Okay. Let's put 1,000 on it instead of 2,500 and 100 on the cannabis. Now, the violation of probation, I can't really help you with. Is that a local case? Because is it? Okay, so is it 2020 CF 10666? All right, so, when the officer finds out that you were on probation, then they're going to file a violation of probation. It's going to come in no bond at first. You're going to see the judge and see what they're going to do with it. But we've got the public defender on that also. All right. Good luck. Mr. Johnson?
Yes, ma'am.
Okay. All right, sir. We have case number 2018 CF 14674BO. That is an alleged violation of probation at this point. We're going to appoint the public defender in the I guess it was originally an aggravated fleeing attempting to elude, and it's alleged that you violated probation without, by getting arrested for armed trafficking on April 21st in Seminole County, and also possession of weapon by a convicted felon. So it comes in no bond on the violation of probation. We'll appoint a public defender, and you should be able to see that judge on the VOP fairly quickly.
Ma'am, I just EOS out of prison yesterday, and I came here, but I was wondering if there's any possible chance I can get a bond on the violation of probation?
Well, the last time I gave somebody a bond on a violation of probation, I thought the judge was going to kill me. I'm not joking. I mean, she was so angry, I don't even know how to describe it. You just told me that you just got out of DOC yesterday?
Yes, ma'am,
All right, so, in the, okay, so like this was alleged to have happened April 21st of 2020, so I think they're giving you a VOP maybe for something that allegedly happened before you went to prison.
It's for the charge that I went to prison for, and I finished my prison sentence, and I'm here for the VOP now. But I was supposed to be over here first before I went to prison, but they just sent me to prison first, so I
Okay.
finished my time in prison. I came
All
here
right, well,
yesterday.
so if there's a mess up, they're going to find it real soon.
Okay.
I don't have enough information here, and I don't touch those probation judges' cases. I just stay out of it, but they're very competent. They'll figure it out right away. Right?
ma'am.
Are you telling me you thought you finished the sentence and now there's more?
Yes, ma'am. I was expecting to go home like,
Right. Okay. Sometimes there's some little thing left that has to just be cleared up. And I think you'll find that it'll happen pretty quickly, that they'll figure out whatever it is, if it's a mistake or not. Good luck. Is this Mr. Ortiz? Yes. Thank you, sir. Okay, it's case number 2020 CF 461680. And I don't know where your public defender form is, but I'm fixing to point one anyway, because you probably need one. All right?
Yes.
Okay. The allegation was that you were on probation from back in April 7th of 2021 on a felony battery, and that allegedly you didn't show up for probation and moved. So they came and found you. And the judge will probably see you, within a few days to a week, and you'll have the public defender and see what has to happen. All right, good luck.
For the record, you're holding him no bond?
Yeah, I'm sorry. We'll state it, no bond. Is this Mr. Weathers?
Yes, ma'am.
Okay, sir. Okay. The case number is 2019 CF 13294. And you probably already have a public defender maybe on this?
He does.
He does, okay, thank you. So the allegation is that you've been out on pretrial release for a grand theft third degree, and allegedly you violated pretrial release by getting arrested again on February 6th by the Boynton Beach Police Department for resisting without violence. And Judge LeBlanc set the bond at $5,000. I don't know if it's the same one that you're going back to, but I probably want to respect that. Yeah, it is. It's Judge LeBlanc. So that's his bond. And if you do bond out, come back to court and talk to him. And if you don't bond out, ask your lawyer to see if you can't go see Judge LeBlanc on that question of the bond. Good luck. Is Mr. Whitlock?
Yes, ma'am.
Okay, thank you, sir. We have case number 2021 CF 581280. And I don't see a public defender form, but you might need one. And they're probably going to ask me to appoint one anyway. And so I'll probably do that. Let's see. And then there's a 2019 CF 4555 in Division 19, which you were on probation for. And the new case, the 5812, is an alleged fleeing and attempting to elude possession of drug paraphernalia. So, all right. Okay, so allegedly having cannabis while on probation for having cannabis. And then, the fleeing and attempting to elude. Okay. All right.
Sir, in regards to bond on the fleeing and attempting to elude, state would ask for at least $5,000. It's particularly dangerous in that it's alleged that the officer was standing next to the driver's side window with their lights activated when the defendant put the vehicle in drive and drove away from the lawful traffic stop. It's particularly dangerous for that particular officer, as well as fleeing and attempting to elude. It's just dangerous for the community in generally because the driving pattern is erratic. So I'd ask for $5,000 on that bond.
All right, well, sir, I hope you're coming to the conclusion that pot isn't worth all this, but I'll have to, keep you in on the violation of probation because the felony judge wants it to come in no bond. And then 5,000 on fleeing, attempting to elude. Sometimes, we go higher on those. We do take them pretty seriously. I mean, I understand that you're pretty young, aren't you? Well, young to me. People get scared. But,
actually was.
cops, don't say anything about your case because you're already in big trouble. It's just really dangerous to the cop when you do that. So $5,000 bond that's kind of minimal on that charge. So that's what I'll do, and I'll leave it at 100 on the possession. I don't think most of us care about the cannabis at this point, but, you just can't do it this way. Good luck. Just get yourself a marijuana card, except it costs more that way. Okay, is this Mr. Acevedo?
Yes.
Okay, thank you, sir. Okay, we have an out-of-county warrant from Osceola County in regard to an alleged fleeing and attempting to elude and operating a motorcycle without an endorsement. Case number 21 CF 1318. And on the fleeing and attempting to elude, the bond was at 1,000, and on the motorcycle without an endorsement, it was at 500. That's kind of how they do it in Osceola County. I don't really have any information, much do I, about when this happened. Okay. So I can't really.
Your Honor, state just asked that you take no action on his out on bond.
Right, because I'm not sure that this one.
I'm not sure which predates.
Right, okay, so we're not going to do anything. We're not going to revoke the bond on the false report charge that you have in Orange County. You do have a return date on that. So I can't tell you at the moment what that is, but you need to make sure that you follow up with your court dates. In the meantime, if you bond out for the Osceola charge, it's $1,500. If you don't bond out, they'll get you over there pretty soon.
So, question, I can bond out today, right?
I think so, because we're not going to hold you on the Orange County charge. So but just come back to court on the Orange County charge and bond out on the Osceola, and then you have a court date in Osceola too.
All right, so they can come here and bond me out, right?
I'm sorry?
If they can come here and bond me out today, right?
Yes.
All right, thank you.
You're welcome. Is this Mr. Baker?
Yes, ma'am.
Okay, thank you. Sir, you have, let's see what we have here. Looks like we have a warrant from Manatee County, 2000, well, I don't know what the case number is.
A warrant for Manatee County.
Yeah, Manatee. I'm sorry, I don't have much information about it. All I have is like a little teletype with it, like 2 sentences. But it's allegedly a burglary of a structure with a bond of $1,500. And if you bond out, you'll have a court date in Manatee County. If you don't bond out, they'll come and get you. It might take them a few days, but they'll give you a ride over there.
Where's
Your Honor,
Manatee
I believe
County?
it's 2021 CF 2240.
Okay.
Where's Manatee County, man?
It's on the west coast of Florida.
And you said it's for a burglary of a structure?
Yeah, but I'm not gonna be able to tell you much because all I got is 2 little lines.
Right, right. Another thing also though, because the initial charges I came here on, I didn't go to initial appearance on. I was trying to figure out because,
Why not? Well, I've been doing this for a couple of days now because they pulled me out of retirement. And although I'm familiar with the way we did it a few years back, what's going on right now is it seems like a lot of people are, if they, either they're in the hospital or they're sick or they are aggravated and they don't want to come to court, the public defender just covers for them and says, Judge, we'll just cover for them and, let's do the paperwork and move it on. I think, now that I'm thinking about it, I bet you it was because of COVID, because they don't want to bring everybody up here if they don't want to, or if they're sick or whatever. So we're just kind of like running them through. I mean, so if a judge saw your paperwork, they still determined probable cause, and they did whatever they were going to do. But if you were either sick or didn't want to come up.
Your Honor, this case was set for IA. His appearance was waived due to medical.
Medical. There you go. Yeah, we pass them through. We used to not pass them through, but it seems like after the plague, we're doing things a lot different. It freaked me out when I first got here. I thought everybody had the plague in the jail because there were so many of them. I don't know what to tell you, but that's the best I can do.
and you wouldn't have anything to do, like with the bond on that robbery charge, how would I go about getting a bond for that?
It's currently set at 9, Your Honor, due to being a life offense.
A life felony?
It's a robbery with a firearm, yes, Your Honor. It was stated at 9.
Okay, well, sir, I did notice I've actually already passed your paperwork because we just get kind of overwhelmed with the number of cases here sometimes. But before I passed it through, I saw that you had a bunch of stuff. And I would suggest that based upon the type of charges and the number of charges, that you might want to be patient.
Yes, ma'am.
It's getting complicated.
Yeah.
And maybe you can think about the ways to not let that happen in the future. Okay?
Absolutely.
Good luck.
Thank you, ma'am.
Unless you like it in here.
Deleon,
Sir?
Deleon bonded.
Okay. Is this Mr. Foley Walton? Or, I'm sorry, I'm not even looking up for my paperwork before I said that.
Okay.
I really hurt some guy's feelings a little while ago. Because I looked at his name and I thought it was a female and he just got really insulted. Okay. All right, ma'am, we've got some. Oh, let's see what we got. Broward County. Is this a 2000 CF? I can't.
20 CF 2524.
Okay, thank you. 2020. Interesting. I have some different numbers on some of this paperwork, but okay. Ma'am, you have a Broward County warrant in regard to something called possession of Utah. And it looks like it says capious. I don't know if it was a failure to appear, but there's a warrant. It's a no bond warrant on that. And then there's another one from Broward County. Oh, 2020 maybe? Same,
20 MO 2054.
2054. Okay, CF and MO and, okay. And the other one is an alcoholic beverage violation, and I think that's a ROR. Is it?
Yes, yeah.
Okay, your paperwork is easier to figure it out from. So one is a no bond and one is a ROR, but I'm assuming that Broward will come and get you. If it was a failure to appear, ma'am, some of the judges in felony court, they just revoke, and make.
Well, I spent 28 days in jail, and then they let me out. I thought it was done, but I did notice that they had a Zoom appointment for me, and I did do the Zoom for the open container. And as far as the other one, I didn't know it was a warrant. I was still trying to look up information about the Zoom.
Yeah.
They're doing Zoom out there.
Right.
And that's what I was gonna do. It was the Zoom as soon as I found out another court date, but they never posted another court date.
Well, Zoom would be a lot easier than this.
Yes, that's what I was planning on doing. I didn't even know there was a KPS or warrant or whatever they call it.
Well, unfortunately, this is the more difficult way to deal with it, and I'm sensitive to the fact that there might have been some confusion, but I don't have any jurisdiction to change it at this point.
Somebody said the public defender for Fort Lauderdale was supposed to contact today, talk to somebody. The attorneys that are they're posing for me today was supposed to
Contact the public defender here?
Yeah, no, the circumstances in Fort Lauderdale, so I could at least get a bond or something.
Okay, well, they can do that down there, and in which case, if they do, it will be communicated to the jail up here.
Right, that's what I was,
Right, so and I'm not going to supersede anything. Whatever I do here, they would be able to supersede. All I'm doing is staying what they did. If they change what they do, then the jail should pick it up. I'm correct? They'll tell you. Yeah.
Okay, how
'Cause
long?
They don't want to keep you here if they don't
Right.
have to anyway.
Right, and I really got things I'm in the middle of. But how long does it take if they don't pick me up that I get released? Or I can go to Zoom or something?
So, different circumstances. If say they don't give you a break and revoke reverse or lower the bond in Broward County, and you're stuck here for a bit on no bond, that what they're supposed to do is come pick you up. And I don't know how long it takes for Broward County.
We're not sure, Your Honor.
You're not sure? We used to have that happen pretty quickly. I've been, retired for a couple years now, so I don't know what they're doing now with COVID and everything. I mean, it's not like it's some horrible thing. I don't want you to worry that you're going to be stuck in there for a really, really long time. But I can't promise you it's a week. It could be a little more, In Florida, there's no reason why they can't transport relatively quickly.
Okay.
So hope that public defender in Broward gets to the judge and it's something to happen.
Happen today.
Yeah. Well, I think everybody in the jail wants something to happen today, and I
Yeah,
can't
I'm
guarantee
talking
that.
about communication issue.
Yep, and it does happen.
Okay. So what?
Well, no, we're done. Okay, you're welcome. Is this Mr. Hilton?
Yes, ma'am.
Okay, thank you. We have, looks like a couple of out-of-county warrants. Okay, Brevard County, 2020 CF 25582 and 2020 CF 31854. And the 25582 was on a fleeing and attempting to elude. Looks like it came in no bond. Supposedly failure to appear for a hearing, and it's real common to come in no bond on those. The other one that is aggravated assault on a law enforcement officer, another failure to appear, so those are no bond cases. But Brevard, I think, is probably going to come here a little faster than the South Florida case. Good luck.
Okay.
Right. Mr. Jackson?
Yes, ma'am.
Okay. This is 13 CF 2746 out of, it looks like Lake County. And it looks like a violation of probation on a possession of MDMA case. It's at no bond. I don't have any information about what the alleged violations of probation are, but I think that Lake County will come pick you up pretty soon, appoint the public defender, and let you know exactly what the allegations.
It's a, if I may
You
speak.
don't
I
have to
would-
say anything about the effects of your case because you're at significant danger of accidentally incriminating yourself.
It's a money violation, but yes, ma'am.
Yeah, no, I just, because your lawyers, I promise, don't want you to talk about it.
There's no possible way of a bond on this charge at all, period?
No, sir, I don't have a jurisdiction to touch a Lake County case.
Oh, okay, okay, all right. Yes, ma'am.
All right, good luck.
Yes, ma'am.
Okay, Ms. Zagenfuss? Right. It looks like we have 3 out-of-county warrants here. Maybe 2021 CF 634, 635, 636. They're out of Hernando. 634 was in relation to criminal use of personal ID. And the bond is 2,000. Each one of these is 2,000. I don't know if these are new cases that they just got some warrant on, or if there was some other circumstance, but there's 3 of them out of the same county. Each of them is 2,000. If you bond out, make sure you go back to that county for your court dates. And if you don't bond out, they will come get you. I don't know exactly when, but it's not too terrible. It's not the most convenient way to go, but
Yeah.
they'll make it happen. Good luck.
Thank you.
You're welcome. All right, 33-day motions. We have some other stuff. We're done? Okay, cool. Thank you, folks, very much. We'll be adjourned.